nyo na kami ay maliwanagan, magkaroon ng produktibong diskusyon, mga kaisahan na tayo rin po ang makikinabang sa bayan para sa higit na pagtatanggol at pagpapabuti sa mga bata. Sikapin po namin suriin ng mabuti para sa higit na kapakinabangan ng ating lipunan ang gagawin namin ngayong umaga sa paghaharap ng iba't ibang punto at opinyon. Lahat po ng ito ay idinudulog namin sa inyo sa nakatataas, Panginoon, sa ngalan ng Ama at Espiritu Santo. Amen.
The chair would like to recognize the presence of the following members: the Honorable Tom Villarin, Deputy Speaker Honorable Fred Castro, the Honorable Arnolfo Tivis, the Honorable Carlos Sarati, and the Honorable Arlene Brasas. May I request the committee secretary please recognize the resource speakers present in today's hearing.
We would like to acknowledge and welcome our resource persons present in today's hearing. From the PNP, General Benjamin Magalong, Deputy Director for Operations. Mr. Francisco S. Cruz from the CIDG PNP. Albert Alfonso Ayoso from CIDG. Rudy Gahar, CIDG. Gerald Prieto, OTOCO. Sancho Mercado from OTPOCO. Manavida Conder from Balay Rehabilitation Center. Rowena Ligaspi from Children's Legal Rights and Development Center. Adelma Atienza Linatok, likewise from Children's Legal Rights. Geraldine Enaje, Children's Legal Rights. Nenita Drede, National Advocacy Office, also from CLRDZ. Rome Dangeto, Mr. Eliseo Rasco from the CIDG. Police Chief Superintendent Eliseo Rasco. Police Chief Superintendent Francisco Ebreo, also from CIDG. Assistant Regional Director of the NBI, Attorney Ruel Bolivar. Also, Attorney Julio T. Cahigan Jr. from NBI. And Lieutenant General Roland de Tabali, our Sergeant at Arms of the House of Representatives. Trisha Oko from Juvenile Justice and Welfare Council. Deputy Director Ferdinand Lavin of the NBI. Attorney Rigel Salvador from the Public Attorney's Office. Attorney Demetir Huerta from the Public Attorney's Office. Attorney Shara Mangoba, State Counsel from the Department of Justice. Attorney Romel Alim Abitria from HLAF, Human Rights Organization. Melanie Ramos Ilana from PAYO. Bing Diaz from Juvenile Justice Network Philippines. Attorney Christopher Claudio from HLAF, Mr. Carlo Manano from Salin Lahi, Michelle Munoz from UNICEF. Commissioner Karen Dumpit from the Commission on Human Rights, Attorney Maria Michelle Munoz also already. And also Ms. Rosalie Dagulo from the Department of Social Welfare and Development. Meron pa po ba tayong hindi natawag? Please let us know.
Good morning again and welcome to this hearing. Today, the Subcommittee on Correctional Reforms under the Committee on Justice is formally constituted to take up matters of national importance. It may be recalled that the Mother Committee recently conducted grueling and lengthy deliberations, a total of 47 hours, on House Resolution number 105 entitled Resolution Directing the Committee on Justice to conduct an investigation in aid of legislation on the proliferation of drug syndicates at the New Bilibid prison. During the hearings of the committee, some members, resource persons, and witnesses raised important collateral issues that the committee deemed needed further investigation. Before the adjournment of the October 17, 2016 meeting, the committee resolved to conduct a motu proprio investigation in aid of legislation on these issues. To wit, number 1, the riot inside the National Bilibid prison, the report of General Magalong on the non-inclusion of the PNP, CIDG, and PDEA in the December 2015 Oplan Galugat, the status of the warrant of arrest issued by the committee against Rooney Dayan, and the anomalies in catering service of the NBP involving former Bureau of Corrections Director Rafael Ragos. These are issues that the members of the committee believe should be delved into deeply in our efforts to improve the administration of justice in our country. The Mother Committee referred these issues to the Subcommittee on Correctional Reforms, considering that the issues involved fall within the jurisdiction of this subcommittee. The Subcommittee on Correctional Reforms fully supports the vision and mission of the Committee on Justice to institute policies and programs geared towards strengthening the correctional pillar of the criminal justice system through legislative via. The conduct of a motu proprio investigation by this subcommittee is a way forward to determine what legislations are needed to implement this reform. The recent investigations in aid of legislation on the proliferations of drugs inside the NBP open all our eyes to the gravity of the situation. It is not a stretch to say that the whole nation was appalled by the testimonies and revelations of resource persons and witnesses that drug trafficking, murder, and other crimes are still being committed inside the NBP. These crimes could not have been committed without the participation of corrupt officials and employees of the Department of Justice, the Bureau of Corrections, and the NBP. Eventually, the subcommittee will aim to visit certain correctional facilities across the country, including but not limited to those in Davao, Cebu, Palawan, Sablayan, Manila, and Quezon City, to give us a clearer picture as to the state of our jails nationwide. We also hope to be able to study the best practices in prison management and observe firsthand the modern facilities in countries with successful prison systems. In light of concerns raised about the feasibility of the planned transfer to a new prison facility in Fort Magsaysay, Nueva Ecija, we will also study further our regional facilities whether our regional facilities could instead be expanded and upgraded to help ease the congestion in the NBP. Naturally, we will also have to revisit the Bucor Modernization Act to finally address the continued deficiencies in facilities as well as the management and security aspect of the NBP. One particular question which has arisen from the circumstances is whether we come up with this legislation that will provide for the Philippine National Police Special Action Forces to continue guarding the NBP. Barring this, we need to determine as soon as possible which entity will be tasked with securing the NBP. The second part of our agenda concerns the House measures that the Mother Committee referred to us pertaining to the lowering the minimum age of criminal responsibility. These bills consist of House Bill numbers 2505, 935, 1609, 2009, and 3973, authored by no less than Speaker Pantaleon Alvarez, Deputy Speaker Fredinel Castro, and Representatives Yap, Tiangco, Cagas, Acob, and Swansea. The subcommittee has invited concerned government agencies and various non-governmental organizations to share their position regarding this matter. Allow me to give the legislative history of minimum age of criminal responsibility. The revised Penal Code of 1930 set the minimum age of criminal responsibility to 9 years old and below. In 2006, the minimum age was raised to 15 under Republic Act number 9344, otherwise known as the Juvenile Justice and Welfare Act. During the last Congress, there were bills filed to amend RA 9344 by lowering the minimum age of criminal responsibility from 15 to 12. On July 23, 2012, RA 9344 was amended by RA number 10630, but the minimum age of criminal responsibility of 15 years old was retained. This 17th Congress, there are 6 bills setting the minimum age of criminal responsibility from 15 to 9. I hope that this subcommittee will be able to exhaustively discuss the issues involving our children in conflict with law and to come up with necessary legislation that is more responsive to the needs of the time. Of course, with all your support who are here present today. Thank you. The Honorable Deputy Speaker Castro, if you have any motion for regarding to the calling the roll.
Mr. Chairman, I move that we dispense with the calling of the roll.
There is a motion duly seconded that the calling of the roll shall be dispensed. The chair hears none. The motion is approved. In the order of business today, item number 3, this is in relation to the investigation in aid of legislation on the following matters. The riot inside the NBP on September 28, 2016. The report of General Magalong on the non-inclusion of the PNP, CIDG, and PDEA in the December 2015 Oplan Agalugat. The status of the warrant of arrest issued by the committee against Ronnie Dyer and the anomalies in catering service of the NBP involving former Bucor Director Rafael Ragos. Considering that our resource speakers present today in relation to this subject matter had shared their views in relation to this matter, so in order to expedite our proceedings, I will now allow members of the House to ask clarificatory questions in relation to this matter. And the chair would like first to ask the Philippine National Police. I understand the CIDG Deputy Director General Rasco is here. Deputy Director General Magalong is also here. Probably you can give us an update or the result of the investigation in relation to the riot inside the NBP, if it is a riot, on September 28, 2016. After that, we would also listen from the DOJ and the NBI. Probably you can give us a brief highlights on the result of the investigation or an update of this case. First, may we hear from Director Magalong?
Mr. Chair,
honorable members of this committee, magandang umaga po sa inyo lahat. With your indulgence, Mr. Chair, we have prepared a briefing presentation and this will be rendered by Police Superintendent Ebreo, who headed the investigation of that stabbing incident at the NBP, Your Honor.
The General Rasco of the CIDP will be the one to make the presentation.
Your Honor, it will be Police Superintendent Ebreo, who personally led the investigation of that stabbing incident, Your Honor.
Okay, Police Superintendent Ebreo is recognized for the presentation of this particular report.
Honorable Chair of the subcommittee, sir, honorable members, and resource speakers, good morning. I'll be presenting to you the result of the investigation we have conducted with regards to the stabbing incident that transpired at Building 14 of the NBP last September 28, 2016. We conducted the investigation purposely to establish the facts and circumstances surrounding the stabbing incident, identify persons involved, determine whether or not there were lapses on the part of on-duty personnel of the Bureau of Corrections and the NPSAP, and ascertain their criminal and or administrative liabilities if there is any. The investigation was conducted upon the request of the Bureau and the pronouncement of DOJ Undersecretary Renato Orseo a few hours after the incident occurred at the NBP. For the facts of the case, on September 28, 2016, at about 7:45 in the morning, an alleged riot erupted inside the mess hall of Building 14 NBP in Muntinlupa City, which resulted in the death of convict Tonico and the wounding of high-profile inmates J.B. Sebastian, Peter Co., Vicente C., and Terence Dongel. Shown on the screen is the sketch map of Building 14. The portion which is covered in red line is the crime scene, the mess hall. Next slide. Crime scene 1 is the makeshift room of Tonico. Tonico is the one who died during the incident, while the crime scene 2 is the entire mess hall area. Shown on the screen is the picture of the mess hall building. The crime scene 1. Next, please. This is the actual picture of the crime scene 1, the makeshift room or kubol of Tonico. That's the crime scene. Next slide, please. And this is crime scene 2, the mess hall area. Next slide. The basis of our findings are as follows. The sworn statements and interviews with personalities involved, the inmates, Bureau personnel, staff, and Bureau officials, CCTV footages, hospital records, medical legal reports, and evidence collected by the Bureau at the crime scene. For the investigated findings. 1. No riot or tumultuous affray occurred. What transpired were two separate and simultaneous stabbing incidents inside the makeshift room of Tonico and at the mess hall area. Number two, the incidents were triggered by separate causes, and there was no showing that they acted together in a disruptive and tumultuous manner in carrying out a common purpose. Number three, illegal drugs still exist inside Building 14. Based on evidence and the result of the drug test to the inmates, including the deceased Tonico, and the records on seized illegal drugs and paraphernalia from the National Penitentiary. Number four, inmates Clarence Dongel, Edgar Cinco, and Thomas Doniña may be held liable for the incident. Dongel for Tonico's death and for the injuries of Peter Co and Vicente C. Edgar Cinco for the injuries sustained by Peter Co. Tomas Doniña for the injuries sustained by J.B. Sebastian. Number five, the on-duty PNP staff personnel present at the time of the incident acted with regularity in the performance of their respective duties and responsibilities. The Bureau of Corrections and NBP leadership immediately reacted, and the course of action they had undertaken in response to the incident were deemed appropriate. Number seven, personnel of the NBP investigation section, acting with their legal mandate, conducted an investigation, but they have limited knowledge in crime scene filing, collection, and preservation of evidence because they have no standard investigative procedures in crime scene processing. For our recommended courses of action, one is formulation of Bureau of Correction standard investigative procedures and crime scene processing protocols to be incorporated in its operational manual. Installation of additional CCTV cameras in all common areas and individual cells. Segregation of inmates according to nationality, crimes committed, prison terms, notoriety, and the gang affiliation. Issuance of operational guidelines to provide for delineation of duties and responsibilities between the Bureau of Correction and PNP SAP personnel. Regular conduct of joint SAP Bureau Security Survey and Inspection, counterintelligence operations. 6. Cases involving deaths be subjected to the standard crime scene investigation and processing by either the NBI or the PNP, whichever is deemed appropriate. Major cases such as killings, rape, illegal drugs, and other similar incidents be reported to the local police station for purposes of crime reporting and recording. Metal detectors should be installed and K9 units be deployed in all entrances and visiting areas of the maximum security compound, especially at Building 14. Crime scene investigation training activities and first responders course for NBP investigation section and PNP SAP personnel. That's all, sir, and good morning.
Okay, thank you very much, Superintendent Edrio. We have from the Department of Justice representative, considering that it is the Bureau Court under your care, on your comments or your position in relation to the report of the Philippine National Police.
Yes, good morning, Mr. Chair. For this matter, sir, My instruction to attend this hearing refers only to the position of the department on the reduction of the MECR. I understand that there should be another representative from the department who is authorized to give comments on this issue, sir.
And may we know who is this other representative in your department so that he or she can shed light on this particular circumstances?
Sir, as with, according to my conversation with the proper office in the department, the matter is under the office of Undersecretary Orseo, and I have no idea who he designated to attend for this matter, sir.
May I know from the committee secretary whether Undersecretary Orseo was notified on this particular hearing today?
Yes, sir. Your Honor, the standard procedure for inviting our resource persons is that the invitation is addressed to the head of the agency, and the head of the agency will be the one to farm out the invitation to the person knowledgeable on the subject matter. Because at that time, we don't have any idea who is the person or office official of the Department of Justice is knowledgeable on the subject matter we discussed this morning.
And the Secretary of Justice, was he properly notified on today's hearing?
Yes, Your Honor. They were notified at least how many days since 2 weeks ago.
And please convey to the Honorable Secretary as to the status of the absence of his authorized representative as manifested by the Chief State Prosecutor, who is representing DOJ on another subject matter.
Your Honor, in fact, yesterday there was another hearing by the subcommittee on the judicial reforms, and we reminded the Honorable Secretary about the meeting today, and although he manifested that he might not be able to attend personally, and will try to send somebody else.
Okay.
Mr. Chair.
Yes, the Honorable Sarate.
In the absence, Mr. Chair, of representatives from the DOJ or the VCOR, probably in the next hearing they can come, but if the Chair may I just ask some clarificatory questions from the report presented by Superintendent Gabriel.
Before I will recognize you for such, we will first hear from the National Bureau of Investigation whether they have participation or what is their role, considering that the Bureau is their colleague, another allied agency under the Department of Justice. The Honorable Deputy Director.
Good morning, Mr. Chair. Good morning, Your Honors. The NBI, on its own initiative, went to purposely conduct a separate investigation in the matter of the riot, the alleged riot. However, when we found out that the CIDG was already on top of the case, we deferred our action, especially so that the CIDG acted on the pronouncement of DOJ Secretary Orseo. We did not continue with our investigations, Your Honor, insofar as the riot in the Philippines is concerned. The riot of September 2016, Your Honor.
Okay, the manifestation of the Deputy Director of the National Bureau of Investigation is duly noted. The Honorable Sarate is now recognized for his interpellations to the resource speakers.
Thank you, Mr. Chair. To Superintendent Gabriel, you mentioned in your report that you found that there was no riot, and in fact there was no tumultuous affray that occurred during that incident. Now, I did not find any statement as to what prompted that incident. It was a very high-profile incident. It was very well reported in the media. There are a lot of speculations as to why it happened. So, can you please enlighten this committee during your investigation, what did you find? Why it happened? What was the motive, for example, of inmate Donggain in killing Mr. Ko and etc. Mr. Chair.
May answer.
Thank you, sir. Based on our investigation, sir, there was two separate stabbing incident that was almost simultaneous. The one is the stabbing incident that transpired at the makeshift room of Tonico, involving inmates Dumel who went there to caution Tonico, Peter Ko, and Vicente C to stop from using illegal drugs. But prior to that incident, inmate Edgar Cinco tell inmate Dongael that he saw the three in a packed session, and he cautioned them because all of them will be implicated if they were caught by the staff personnel. And Edgar Cinco also told Dongael that he was rammed on his neck by Tonico because and that prompted Dongael to go to the said room. While cautioning the three, Tonico and Dongael had an altercation, and Tonico suddenly stopped Dongael, which he fired, thus it landed on his left thigh. When being attacked, inmate Dongael fought back and was able to grab the ice pick from Tonico. Simultaneously, he confronted Peter Ko and Vicente C with the use of ice pick. Edgar Cinco saw the commotion and recognized his gangmate. Dongael being attacked, so he responded and managed to grab the ice pick from inmate Peter Ko. And he was forced to use the same weapon to overcome the continuous attack of Peter Ko against him. This incident resulted in the death of Tonico and the wounding of Vicente C, Peter Ko, and Dongael. While the second stabbing incident stabbing incident transpired inside the muscle area, involving inmate J.B. Sebastian and inmate Thomas Dudinya. In his sworn statement, inmate Dudinya averred that he take the opportunity to stop J.B. Sebastian in order to prevent him from testifying in the House inquiry.
Okay. Before the Honorable Sarati could pose further questions, the Chair would like to recognize the presence of another members of the House. One is our Vice Chairman, the Honorable Strike Revilla, and the Honorable Estelita B. Swansing, First District, Nueva Ecija. The Honorable Sarati, you may continue.
Thank you, Mr. Chair. So, ang lumalabas dito, Superintendent Ebreo, habang kakagulo sa loob ng kubol ni Peter Ko, dahil sabi nyo, simultaneous, sinamantala ito ni Dunginya, para naman doon sa mess hall ay inatake niya, sinaksak si JB Sebastian. At sabi nyo nga ay para hindi ito mag-testify sa naging pagdinig dito sa kamera. Hindi nyo ba naisip na yung pag-atake doon sa pag-imbestiga ninyo, hindi nyo ba na-establish na kaya parang mayroong diversion na kaguluhan doon sa kubol ni Peter Ko para rin matagumpay na atakihin si JB Sebastian dahil sabi nyo nga ang purpose nun ay to prevent him from testifying. And na-establish nyo ba sino naman ang bakit yun ang motibo ni Dominia at kung may nag-utos sa kanya, sino ang nag-utos sa kanya na wag saksakin si JB Sebastian para hindi ito makapag-testify? Were you able to establish that in your investigation, Mr. Chair?
Yeah, go ahead,
Ano, sir?
Superintendent NBP.
Ayon sir sa sinumpang salaysay ni Tomas Dominga na ibinigay niya noong ika-8 ng October 2016 sa harap ni Atty. Rigel Salvador at Atty. Dimitar Huerta ay inilat niya na noong September 28, 2016, bandang 7:45 ng umaga, ay pinatangkan niyang patayin itong si JB Sebastian sa kadahilanan may kumausap sa kanya na isang dati niyang kasamahan sa Philippine Navy na dapat ay gawan niya ng paraan na mapatahimik at mapatay si JB Sebastian para hindi siya makapagsilta laban kay Ma'am Laila de Lima ukol sa paglaganap ng droga sa New Bilibid prisons.
Mr. Chairman.
Yes, before I recognize the good Deputy Speaker, we would like to know if Honorable Sarate is already with your interpellation.
Just to give way to...
My intention, Mr. Chairman, is not really to interrupt the interpellation being conducted by Congressman Sarate, but it is simply an interjection because while in the process, I observed that Superintendent, please correct me if I am wrong, Superintendent Ibreo is reading a salaysay. Therefore, I suppose that affidavits have been submitted in the course of the investigation in addition to any other documents that may have been furnished the lead investigator who conducted the investigation in the Bilibid prison. For purposes of expediency, may we request Superintendent Ibreo to furnish the members of all affidavits and all documents and reports which may have been gathered during the investigation in the New Bilibid prison, Mr. Chairman.
Thank you, Deputy Speaker, for your interjection. And the Chair would like to inform the members of the committee and the good Deputy Speaker, just this morning, the committee secretary is in receipt of this official report together with all the annexes. And I'd like to ask Superintendent Ibreo if the one which was pushed or asked by the good Deputy Speaker is one of the annexes that is being attached in this report that your office has submitted to the committee.
That is part of the report, sir, submitted this morning.
Okay, thank you very much for that. And in relation to the request of the Honorable Deputy Speaker, I am directing the committee secretary to furnish the members present who are interested to have a copy in relation to what was asked by the good Deputy Speaker. Deputy Speaker?
Because, Mr. Chairman, with that procedure, we will be able to conduct interpellation by the members of the committee more intelligently, and all those which are already admitted in the affidavits or reports could already be dispensed with, thereby abbreviating proceeding, Mr. Chairman.
Okay.
Mr. Chair,
Yes, the Honorable Kong Villarin is...
may we also request that in the matter of the motu proprio investigation in aid of legislation, and the three other matters have been documents already submitted to the committee, or if there has not been documents, may we request also the concerned officials to submit the said documents to the committee.
So far, what the subcommittee has received is only the report of the PNP CIGG in relation to item number 1 of agenda number 3. And with that request, as we go along, we will ask the concerned officials where this subject matter falls into for whatever documents we would like to have in relation to this investigation. Okay, so the members can ask questions, even not limited to number 1 of the order of business number 3, because this 1, 2, 3, and 4 coverage of the motu proprio investigations are interrelated, and this is one of these are those which were mandated to us by the Mother Committee. So you are free to ask questions within the 4 subject matter. Okay, Honorable Sarate.
Mr. Chair, I'll just wind up my questioning.
Okay.
Because I have to attend to the Transport Committee.
Go ahead.
Without prejudice to asking question later on, if I come back. Since you already, in fact, you already submitted a copy of your investigation with the supporting documents. My only question now is, were you able to already file the necessary charges against, because it was a summary, yung binigay nyo kanina, no? That Dunggail, Dungenya will be responsible for criminal charges. But ang tanong ko ngayon, naisampahan mo ba kayong kaso? At sino ang inyong sinampahang kaso in relation doon sa dalawang incidents na yun, yung pagkamatay ni Ko at saka yung pagkasaksak naman doon kay JB Sebastian, Mr. Chair.
Thank you, Your Honor. Since the investigations are conducted is only a fact-finding investigation, a part of our recommendation, sir, is that the filing of the case against Dongel, Doninya, and Cinco will be. It was recommended that the NBP investigation section will be the one to file the case.
So, as we speak now, wala pang kaso?
Wala pa po, sir.
Okay. Tapos, dahil doon sa rekomendasyon, limitado lang doon sa dalawa ang papasampahan ninyo ng kaso. Ganun ba?
Based on the statements and evidences we gathered, there is still no lead that can connect the other personalities mentioned in those solid statements, sir.
That's all, Mr. Chair. Thank you.
Okay, before I recognize the Honorable Villarin, may I recognize the Honorable Deputy Speaker who had asked earlier recognition.
Mr. Chairman, a few questions. You said, Superintendent Ebreo, that so far no case has been filed against the assailant of Peter Ko. Is that correct?
Yes, sir.
And in the same manner, so far no case has been filed against the assailant of JB Sebastian.
Yes, sir.
What takes the CIDG too long to file the necessary case against the assailants of Peter Ko and JB Sebastian?
Yes, sir. As I mentioned earlier, sir, the investigation conducted was only a fact-finding investigation to determine who are liable, criminally or administratively liable regarding the incident, sir. So we are recommending that filing of the case being handled by the National Bureau of Prisons Investigation Section, sir?
Well, can CIDG, in view of delay on the part of the Bureau of Correction, not take the initiative of filing the case against the assailants of J.B. Sebastian and Peter Ko?
So since the place where the incident happened is under the jurisdiction of the National Bureau of Prisons, and their investigation also has a mandate to do the filing and the investigation and filing of cases, we recommended, sir, that they be the one to file the case, sir.
Is this not an awkward procedure? That you are the ones who conducted the investigation and cases will have to be filed by another entity or another division or department of the government? Will it not be more reasonable, logical, and proper that the investigator or the investigating agency itself files the necessary case against the assailants of Sebastian and Peter Ko?
Before I recognize Superintendent Ebreo to respond the question, considering that the question calls for a policy determination, may we ask the higher officer? We have heard the Deputy Director of the CIDG, or Director Magalog, who is the Director for Operations of the entire Philippine National Police. Would you mind to make a very responsive and intelligent response to the question raised by the Honorable Deputy Speaker?
Mr. Chair, Your Honor, their mandate was purely fact-finding investigation. That's the reason why most of their findings are actually statement of facts. Now, with the recommendation, which I am aligned with the recommendation, Your Honor, is that they have recommended that the Bureau of NBP will file the necessary case, being the nominal complainant.
Mr. Chairman, going back to my question, and now this is addressed to General Magalog. Is this procedure irrational, improper, inappropriate, that it becomes more circuitous? That investigation was already conducted by the CIDG, while the filing of the case will still have to be delegated to the requesting agency of the government?
Your Honor, we're just following the right procedure. That is the similar case with the Mama Sapano investigation.
If you ever followed the request and the procedure, did you ever come into your mind to recommend a revision of the procedure that the one who investigated should be the one to file, at least in your recommendation?
It makes sense, Your Honor, and we will look into it.
Another question, General Magalong, Superintendent Ebreo, is, you said a while ago that identity have not been discovered yet, apart of course from the assailants of J.B. Sebastian and Peter Ko. Other personalities privy, whether by direct participation or by induction or by any other mode of participation, have not yet been identified. Is that correct?
No, sir. What I mentioned, sir, is the other persons mentioned, particularly on the Sinumpang Salaysay o Tomas Duninya, we don't, based on his sworn statement, there is no strong link or strong evidence that the person he mentioned is really involved in the said plan.
If that is the case, Superintendent Ebreo, what steps, if any, have you taken to identify and gather evidence against the person who is identified and mentioned in the affidavit, in order that you may be able to recommend his indictment against for stabbing Peter Ko or J.B. Sebastian or both?
So we continuously conducting follow-up investigation regarding this sworn statement of Tomas Dominguez, sir.
What follow-up investigation are you conducting? And what so far is the result of that follow-up investigation?
So far, sir, negative pa yung result ng effort namin, sir. And although negative pa, sir, yung result ng effort, sir.
Since when has it been negative?
And also, sir, we already have concluded the investigation. So, yung effort, sir, to continuously conduct the other investigation, sir, is temporarily held in abeyance, sir.
Meaning to say that your investigation is not a continuing investigation.
Because, sir, we have already made our conclusion, sir.
Therefore, you will just allow that to die in its natural death simply because that you have concluded your investigation, and therefore you will hold it in abeyance indefinitely without any action.
No, sir. If we will be directed to continue the investigation, sir, or pursue further investigation, we will do so, sir.
That's why I am asking you, since when has it been negative? And since when had it been held in abeyance? Because after that, if you tell me that it was held in abeyance already for about 2 months or 1 month, therefore, the next question that I am going to ask you is, why do you allow it to stagnate to so long without conducting any action?
Because, sir, as I mentioned earlier, sir, that there was already conclusion, sir. We had already concluded the investigation, sir, and it was already submitted to our higher up, sir.
Therefore, because you have already submitted and concluded your investigation, you will just allow those people who should be indicted with the principal for having stopped J.B. Sebastian and Peter Ko scot-free. And you will not do anything more to discover the identity and bring them in court for prosecution.
Actually, sir, this is not the only case being handled by our officer. So, as I mentioned earlier, sir, the investigative reports was already submitted to our higher ups, and if our higher ups will direct us to continue further investigation or dig deeper to establish the link, then we will do so, sir.
Because of that answer, I will now ask General Magalong. General Magalong, is that the policy of your investigation that you allow things unfinished just because that you want already or you have already submitted your partial report?
Your Honor, immediately after receipt of their investigation report, I immediately called for General Erasco and some of his staff. Unfortunately, Superintendent Ebreo was not present during that time, and one of the big questions that I actually raised was that, were you able to establish the motive? Because when I was reading the entire report, I found out that they have not clearly established the motive. So I gave a directive I gave instructions to Eli Rasco to pursue the investigation, Your Honor.
Do I get it from you, General Magalong, that after the submission of the report, Superintendent Ebreo was already relieved of his responsibility? That's why he was not involved in your discussion about the continuance of the investigation.
Perhaps, Your Honor, he was not informed about my instruction.
Was there no initiative exercised by Superintendent Libreo to inquire from you as to the status of his assignment?
Unfortunately, Your Honor, it is my first time to meet Superintendent Embreo.
In short, you are now again telling me, General Magalong, that there is no coordination between your office and the office of Superintendent Libreo.
Your Honor, I was talking to the Deputy Director for Operations in the person of the General Eli Rasco, Your Honor, who is the supervisor of Police Superintendent Embreo, Your Honor.
Was Superintendent Libreo not given the necessary instruction by General Basco? So that, so that he will continue or pursue the investigation.
Mr. Chair, Your Honor.
General Rasco is recognized to respond to the query of the Honorable Deputy Speaker. Go
Thank you,
ahead,
sir. Sir, as soon as the Superintendent Embreo submitted his final report, we transmitted it to higher headquarters. And also with the instruction that when there are other evidences or witnesses that will be acquired, he will continue his investigation on this incident, sir.
Mr. Chairman, because I find this very illogical, if not revolting, the system of our investigation. That's why perhaps this is one of the primary reasons why investigations are left unfinished and criminals go scot-free, because the investigation is not finished. This observation, Mr. Chairman, is supported by the fact that Superintendent Embreo mentioned a while ago that according to his investigation, he found out that the assignment of Sebastian executed an affidavit that according to that affidavit, someone from the Navy asked him or requested him to stop Sebastian at any cost from testifying. Therefore, there is already a clue who that person is. He is a Navy. Why is it that investigation was not pursued so that finally the identity of that person could be identified and finally the mastermind of the attack or stabbing incident against Sebastian and Peter Ko could be properly identified? In any event, Mr. Chairman, while I have so many other questions to ask in the relation to the investigation being conducted at the NBP in relation to the stabbing incident in the raid, I will in the meantime defer further questions until after that this representation, Mr. Speaker, Mr. Chairman, is furnished with the annexes of the report submitted to the subcommittee for a more intelligent discussion the next time around. Thank you, Mr. Chairman. Thank you, General Magalong. Thank you, Superintendent Embreo and General Rasco.
Okay, before I'll recognize the Honorable Tom Villarin, I would like first to recognize the presence of two distinguished members of the House, the Honorable Gary Alejano from Magdalo Party List, and the Honorable Rocamora from the Long District of Siquijor. And he was asking first, and then after Honorable Villarin, the Honorable Pinvis. Go ahead, Honorable Villarin.
Thank you, Mr. Chair. First, Mr. Chair, I'd like to manifest that the absence of the NBP and the Bureau of Corrections in this hearing is substantial in terms of, because we are proposing policies here, and that most of the policies that will affect these two agencies, and their absence in this committee meeting perhaps might render the discussions inaquandain. No? So yun lang po yung unang manifestation. But to proceed, Mr. Chair, no, I'd like to ask some questions. No? It was stated by...
With the kind indulgence of the Honorable Villarreal, before we will proceed, just the Chair would like to make a enlightenment with regards to the first issue that you raised, which is very valid. I would just like to inform the members of this committee that yesterday the Bucor chief had conveyed to us the message of their inability to attend today because they had a prior schedule, which is their roadmap planning session of the Bucor. However, as I had mentioned in my preliminary remarks, that there will be subsequent hearings that will be conducted by the subcommittee, one of which will be held also at the National Believed Prison. Other than that, of the other penal colonies, pretty sure they will be present in this particular succeeding hearings. Thank you very much. You go ahead now, the Honorable Villarreal.
Thank you for the enlightenment, Mr. Chair. Now I'll go into the report submitted by CIDG. Well, it was a very straightforward and sort of an elementary report. Because, again, if you would dig deeper, there was no mention of, for example, what are the gang affiliations of these personalities involved. And I assume that these personalities are head of the are head of two major gangs, aggregation of gangs, the Presidio and I think the other one is Carcel. So why was there no mention of the affiliations of these personalities?
Mr. Chair, Your Honor, it was mentioned in our narrative report, sir, the gang affiliation, sir.
Yeah, and considering that these are the top, is it correct to say that these personalities, Sebastian, then belonging to, are the top leaders of this drug, of these gangs inside the Believing?
Yes, sir. So, according to this, James Sebastian is the leader of the Batang Comando, sir. And during interviews with the other Chinese inmates, they agreed that Chinese inmates do not have or wala silang tatak, sir, na a-affiliate lang sila kasi tinutulungan nila, sir, yung mga Pilipinong inmates. Kaya parang ampun lang sila, sir.
Well, considering that the top gang leaders were involved, and in your report you stated that there was no riot, it was seems it was not part of a riot. Is it parang logical to assume na hindi ito talaga away ng mga gangs, and for that matter, there are major issues involved, like you also mentioned that of the personalities that were identified, all of them were found to be positive for drugs. Is it correct to assume that? Assume those issues, Superintendent? Yung una na sinasabi mo na walang riot. But sinasabi natin na may mga gangs yan, so leader na mga gang. So, imposible na hindi magagantihan yan at hindi lalaki yung issue na yan, kung ang apektado mismo yung kanilang mga leader. And pangalawa, sinasabi natin na doon sa inyong investigasyon, yung mga personalities ay positive sa drugs. And in fact, they were doing patch session, sinasabi mo. So ang concern natin dito is yung sinasabi natin maayos na yung NBP ng SAF, when SAF came in, hindi pala totoong nangyari. Is this incidents parang normal na in the course of the parang prison system inside NBP?
Your Honor, sir, Mr. Chair. Base po sa aming sinagawang investigasyon at sa pagtatanong at interview sa mga inmates na andun sa Building 14 at sa Bureau officials, sa Building 14 po ay halo-halo yung mga inmates irregardless of kung ano pong gang affiliation. Gaya po dun sa crime scene number 1, ang magkakasama po doon ay si Edgar Cinco, si Robenchu, si Tonico, at si Tomas Duninyan. Magkakaiba pong gang yun.
Magkakaibang gang, pero sinasabi ko nga kanina, may dalawang major parang groups yan, Presidio at saka Cancel. Did you dig deeper into those two groups?
Tungkol dun sa ang focus ng investigation namin sa hindi na dumating dun sa Presidio and Carcel issue. Ang facts na tinutukan na namin, sir, is yung facts surrounding mismo dun sa yung actual incidents. And pertaining dun sa nabanggit nyo na tungkol na positive lahat sa paggamit ng illegal na droga, ang lumalabas po doon sa drug test result ay yung namatay na si Tonico, positive po yun sa illegal na droga. Then pagkatapos yun po ng insidente, nagsagawa po ng drug test sa lahat ng inmate na andun sa Building 14, ang NBP, at na-find out po na lumabas po sa resulta na yung inmate po na si Dominguez ay positive po sa paggamit ng illegal na droga. At bago naman po nangyari yung insidente yun, nagsagawa po ng Oplan Galugad yung PNP SAP kung saan po ay meron din nagkumpiska ng hinihinalang illegal na droga at paraphernalia sa selda ni Peter ko.
So laganap pa rin yung droga kahit may SAP na doon sa loob ng NBP.
Nabanggit po namin sa report na meron pa rin pong illegal na droga. Pero hindi po natin masabi na kung laganap. Kasi kung tutusin po, yung nakukuha na pong droga ngayon ay maliit na amount lang kumpara po doon sa dating nakukuha. At gaya po ng ibang numalaw na pong insidente, ito po kasing mga inmate na ito ay talaga pong hindi po natin masabi kung may yung bang nakukumpiska sa kanilang illegal na droga ay dati lang andun sa loob.
At batay po dun sa rekomendasyon nyo na may rekomendasyon kayo about segregating, di ba? Yung sa Building 14 ba, hindi nakasegregate yung mga gang members yung sa Building 14?
Nabanggit po kanina, dahil doon po sa Building 14, halo-halo na po, wala na kung kahit ibang gang ka, pwede mong katabi o kasama mo doon sa isang cell block yung ibang klase.
Pero di ba, noon pa, alam natin na mahirap paghaluin, di ba, yung mga gangs. That's logical, no? I mean, if you're running a penal system, para hindi maka-trigger ng talagang away among gangs, kailangan mo silang ihiwalay. Pero dito sa Building 14, it seems, no, na yung mga drug, sabi natin yung mga convicted, no, mga felons from different gangs, and these felons belong to the top, no, parang hierarchy ng mga gangs, no, pinaghalo sila doon. So do you think that's parang isang polisiya na para ma-resolve or immediately meron kaagad na quick reaction para ayusin ang mga problema, mas maganda ipaghalo yung mga leader ng mga gang para sila mismo magre-resolve kung anumang problema o sigalot dun sa kanilang mga gangs.
Yes, General Magano may reinforce Superintendent Embryo.
Mr. Chair, may I ask your indulgence if I can respond to the question?
Yes,
Go ahead.
Kaya po, ako na lang po ang sumagot sa inyo kasi alam na alam ko po yung kung bakit po napunta po sila sa Building 14. There was a sense of urgency kung bakit po kailangan i-isolate po yung mga personalities na lalo na po involved sa pagmamanage po ng droga. So, yung gang affiliation was not at all considered po. Yung po ang ginawa natin doon. And there was an assurance from the PNP sa na i-manage nilang mabuti, making sure that there will be no violence that will happen with regards to yung away po ng mga gangs. So yun po yung assurance noon na naibigay po. Kaya po na-isolate po sila lahat doon. Para po talaga totally, kasi yung Building 14, it has all these special equipment to make sure that wala po pwedeng kumontak. Maski na nakapag-smuggling sila ng mga cellphones, wala akong basta-basta makagamit kasi meron po sila mga nilagay po ng mga hardwares po doon to prevent them from communicating with their contacts outside of the Bilibid. So yun po yung sense of urgency doon, to really isolate them.
Yes, but as you said, ang Building 14 is highly secured at nakatutok, di ba, yung ating pwersa doon.
Yes, Your Honor.
But nangyari pa rin yung insidente, nakita pa rin na may droga dun sa loob ng Building 14. No? And now you're recommending na ipaghiwalay uli itong mga leaders ng mga gangs at gangs bilibid. No? Dahil sa tingin ninyo, hindi effective yung ganon, ipagsama. Ganon ba yung batayan o yung motivation ng inyong recommendation?
Ang maging batayan po ng aming rekomendasyon sa pagsisegregate ng mga preso ay isa lang alang ang kanilang nationality, gaya po ng nangyayari dun sa nakaraang insidente. Malinaw po na yung Chinese nationals, pwede nilang ibuli yung nag-iisang presong Pilipino. Kaya isa po yun sa naging basehan ng aming rekomendasyon. Padawa po ay yung kung ano pong krimen ang kanilang nagawa. At kung gaya pong gang affiliation din, isa rin sa inyong ng affiliation, kasi kung yan po ay pare-pareho, yung Building 14 ay puro komando na magkakasama, magkakilala. Hindi naman po siguro para pag magkaroon pa uli o maiwasan na magkaroon po uli ng ganong insidente.
And lastly, Mr. Chairman, do you think that this recommendation is new o nagawa na natin dati yan? Kasi kung itong polisiya, this policy recommendation of segregating, that's the logical, di ba? Pero sinubukan natin yung ipagsama yung mga leader, tapos hindi na naman umubra. Tapos ngayon, we're going back to the policy of segregation. And do you think that will solve the issue of gun wars within NBP, or do you think it will, sabihin natin, ma-reduce yung mga riots in the National Military Prison? So that's only my thinking aloud, Mr. Chair. And perhaps if NBP and Bucor were here, we could hear more kung ano yung mga policy recommendation. Ang suggestion ko lang, Superintendent, kasi dun sa fact-finding nyo is very basic talaga and we cannot parang dig deeper kung batay dun sa inyong investigation ay yun nga, hindi klaro talaga yung motivation, ano pa. So I could leave it at that, I perhaps commend the CIDGs for doing the investigation, but again, kung mas maaari po, mas laliman po natin, mas from an elementary type of fact-finding, mas gawin na natin tertiary level na fact-finding. Thank you, Mr. Chair.
Okay. Before I recognize the Honorable Davis, I'd like first to recognize the arrival and the presence of our chairman of the Committee on Public Order, the Honorable Ako. Honorable TVs, you have now the floor.
Thank you, Mr. Chairman. Good morning, everybody. Unang-una, nung lumabas tong balita na to, ang unang-unang lumabas may riot. Sabay ngayon, sa findings na pinisinta ng PNP sa atin, walang riot. So, meron akong naaamoy na hindi maganda. So, ngayon pa lang, ang gusto ko malaman kung saan ang galing yung palabas na may riot right from the start. I don't know who to ask, who to address that question. Pero sana nandito yung taga-Bucor dahil sa akin malamang doon ang galing yung may nangyaring riot dahil sila naman yung dapat unang nakakaalam dahil sila yung nandun. If anybody can respond to that question, I will be very grateful.
Considering that the NBP representative and the Bucor are not around, so probably in our next hearing at the NBP, you can reiterate again that question. Yeah. Okay.
Yeah, anyway, sige lang, in line with that, no? Before I forget, I would like to request later for the presence of Bucor and also JB Sebastian, Donggail, and all others involved in the supposed riot. Kaya ako gusto silang imbitahan dahil in line with that question kung sino yung nagsabi na may riot, doon rin natin siguro masusunod kung ano talaga yung motibo. Because I sense a little bit of a cover-up by saying right then and then na may riot. Bakit hindi sinabi na imbestigahan muna natin, kaagad may conclusion na may riot. Then now, I was surprised to see the PNP report na wala naman palang riot. Next, dapat talaga nandito yung taga-Bucor because a lot of this will revolve around them. Anyway, in their absence, matanong ko na lang sa, anyway, nandito naman DOJ, NBI at PNP. Meron bang, sino ang liable kung may nangyayaring entry of security risk items and or drugs in a controlled facility? Not only in the NBP, in, for example, isang kulungan, isang opisina, or ngayon specifically sa NBP, may liability ba yung mga nakaupo doon?
The chair would like to enlighten the honorable TVs that that is one of the ultimate goal that we would like to achieve in this hearing, because in the previous hearing, just like the subject matter number 2, that the agency that has exclusive jurisdiction over the NBP is the Department of Justice. That is even the reason why General Magalong said that the CIDG, the PDEA, were excluded by the former Secretary of Justice of that Oplan Galuga. That is why, in our desire to come up with the necessary legislation, we can probably generate whether it is proper that if we can come up with a legislation that if the issue is drugs, then PDEA would have jurisdiction. If the issue would be other crimes, then the Philippine National Police would have jurisdiction. And that is the substance of the memorandum of agreement which was signed before but was not implemented by the former secretary for PDEA to take over jurisdiction on drug cases inside the Philippines. So that is one of the goals in this committee hearing of the subcommittee on correctional reforms, because that will lead now to revisit the Bucor Modernization Act.
Yeah, Mr. Chairman, I'm asking all these questions in aid of legislation later and also leading to number 2 of our agenda. No? Anyway, ngayon pa lang, from the, if I may ask General Magalong, from the PNP standpoint, no? Kung may nangyayaring gano'n, halimbawa, may droga sa building 14 or may security risk items like ice pick and the like, sa PNP standpoint, equally liable ba ang mga nakaratay? Or wala silang, they are zero liability?
Mr. Chair, Your Honor, if I may explain it simply, kung sino po yung may control over the facility, siya po ang liable dapat at accountable po dun sa pagpasok po ng mga contraband.
Yeah, thank you. That was what I was trying to drive at. Because parating, kanina narinig ko, na-file na ba ng kaso yung nanaksa, na-file na ba ng kaso yung tumira ng droga, pero wala akong narinig, na-file na ba yung kaso yung nagbabantay. And again, in a control facility, I also believe na liable yung, equally liable yung nakabantay. I would like to throw the same question to the DOJ, if I may, Mr. Chairman. They might have another stand. Because we need all this to facilitate, for our data in aid of legislation later.
Unfortunately, the state prosecutor who represents DOJ manifested earlier that her...
She's not in the capacity.
Yeah, because she is authorized only to give representation on the second item of our agenda, which is the juvenile justice welfare act.
See, anyway, I would like to reserve that question, and if you can put that on record that the next time the DOJ comes, itanong na natin yun sa kanila. NBI na lang, because they will all be involved. Yeah. NBI, what's your stand on the matter? Equally liable ba yung nakabantay or may kasalanan lang yung nanaksa at tumira ng droga sa loob ng NBP?
Your Honor, in consideration for institutional respect with the findings of CIDG, I can only speak for the NBI concerning our own jail management system, Your Honor. We have at the NBI the Security Management Division, and we have both administrative and criminal sanctions if there are findings of complicity or connivance with officials of the NBI manning our jail. The detention facility, Your Honor, at the NBI is only a temporary detention facility. However, if there are contraband that would get into the detention facility, if there are findings that some of the officials of the NBI have connived or have participated in the facilitation of the entry of contraband, then we will impose our own set of penalties, Your Honor.
Okay. Ibig sabihin, iba yung tingin nyo sa tingin ng PNP. Sa kanila kasi, yung sa sinasabi mo lang, kailangan pa-imbestigahan kung kasama sila. According to General Magalong, the fact na may nangyari, liable na rin yung nakabantay, which I believe should be the right thing, no? Dahil parang remiss ka na sa duty mo nun eh. Anyway, my next big question, Mr. Chairman, is granting, no, from the statement of General Magalong na liable din yung tagabantay, sino ngayon yung dapat mag-file ng kaso against them? That's right. Who will file? Whether it's an administrative case or a criminal case, who should file? Tao ng Bucor, PNP, or whoever.
the record shows, in response to the question of the Honorable Deputy Speaker, the CIDG Director Magalong said that under the state situations, their mandate was only fact-finding, and they will be forwarding the report to the NBP, for the NBP to take the necessary action.
That's not my question, Mr. Chairman. My question was, sinabi kanina na equally liable yung nagbabantay. I'm not talking to any specific. Ang sa akin lang, halimbawa nga, totoo yun, which I also believe should be the case, na equally liable yung nagbantay sa lugar na may nangyaring saksakan. Sino doon ang directly liable? Yung nakabantay o yung head ng institution? And next, sino yung dapat mag-file ng kaso against those who are equally liable? Because in the absence of proper protocol on that matter, then I would suggest that we have to do proper legislation to address that absence of the proper protocol on that. Maybe Congressman Akop can shed light on the matter also.
Yeah, the Honorable Akop would like to share his expertise on the matter.
Thank you, Mr. Chair. I think my esteemed colleague is placing me on the spot. Normally, the office which is directed to investigate the matter would be the one filing the case. Rule of thumb po yun. If the NBI is directed to investigate the matter, then NBI will be the one to file the necessary or appropriate cases insofar as the result of their investigation is concerned. If it is the PNP or the CIDG which is directed to investigate the matter, it is incumbent on them to file the cases pursuant to the pieces of evidence that they have recovered. That is the normal course of things, Mr. Chair.
Okay, the Honorable Tibis.
Yeah. Sir, even though if the order was just a fact-finding investigation, because that's what has been mentioned earlier.
If the directive of the higher agency directing another agency is for fact-finding, then I think the process undertaken by the Philippine National Police is but proper to refer to the matter to the appropriate agency, which is the National Prison or the Bureau of Corrections, for them to assess all the facts that the fact-finding committee has gathered. If it is necessary that pursuant to the recommendation of the fact-finding body, that cases will be filed. Perchance the NBP will file the appropriate cases, both criminal and administrative. Mr. Chair.
Yeah, Mr. Chairman, if I may continue, hindi ko kasi alam kung meron, hindi ko masyadong napansin kung meron doon sa findings nila ng PNP na meron ding liability yung mga opisyal na nagbabantay ng institusyon. Because in line with that, kung malalagay man or madadagdag or it's already there na may liability yung mga opisyal ng institusyon, ang itatatong ko ngayon, kung alam na natin kung sino yung dapat mag-file ng kaso, gusto ko itanong kung may na-file na bang kaso or kailan nila ifa-file yung kaso, kung meron man silang balak mag-file sa mga opisyal ng institusyon na dapat liable din sa mga pangyayari.
May the PNP answer or response to that question?
I'm not sure.
Mr. Chair, Your Honor. Sir, as of this time, sir, there is no case filed yet against the perpetrators because our recommendation is for the Bucor to file the criminal cases against the assailants or perpetrators of this crime, sir.
Mr. Chairman, I'm not talking about the assailants. Ang tinatanong ko, sabi kasi kanina, equally liable din yung opisyal. And I would presume Bucor yung, merong taga Bucor na equally liable. Ang tinatanong ko kanina, kung sino yung magfa-file ng kaso sa mga opisyal ng Bucor na dapat liable at kung meron na bang na-file na kaso dun sa mga taga-Bucor na dapat liable sa mga pangyayari.
Your Honor, in the investigation report submitted by MCIU, the findings was that the Bucor or the NBP leadership, their actions were deemed appropriate or ang binabanggit dito, sir, wala silang liability.
Ngayon, ang sinabi ni General Magalong kanina, iba sa sinasabi mo ngayon. Ang tinatanong ko kasi kanina, kung may nangyaring may nakapasok na droga o security risk items sa isang controlled na institusyon, liable ba ang mga nakabantay? And General Magalong said, dapat, which I also believe so.
Yes, sir. I agree with that also, sir.
Then
Because,
bakit wala sa report na may dapat liable na taga-Bucor na opisyal?
Sir, I think this incident is another case. Because, sir, this is not the case that you are talking about, that a contraband was smuggled inside the prison facility. While in this incident, sir, the incident happened inside, and the findings of the investigator was that the authorities have no control over what has happened.
Hindi tayo nagkakaintindihan. Ganito lang, para simple lang, no? Sabi mo, ibang insidente. Hindi. Dahil kung walang na-smuggle na ice pick at walang na-smuggle na droga, hindi mangyayari yung pangyayari. I'm digging deeper. Ibig ko sabihin, kung nabantayan ng husto na walang ice pick na nakapasok, walang mangyaring saksakan. Kaya, what I was leading to is, dahil may nangyaring ice pick, sino ba ang dapat managot? Pwera lang sa nanaksak. I hope you get me, sir.
Yes, sir. Nakukuha ko po, sir. Pero hindi naman po ibig sabihin na lahat ng nagagamit sa loob ay galing din sa labas. Pwede kong yung mga nasa loob ay minamanufacture ho yung ginagamit nilang armas laban din doon sa kapwa nila.
Nevertheless, kahit minamanufacture sa loob, wala namang steel mill sa loob eh. Meron bang steel mill sa loob ng NBP? Ibig ko sabihin, kung may pinasok na gamit at naging armas, sa tingin ko tama si General Magalong, liable pa rin ang tagabantay. Again, what I'm trying to drive at is, meron na bang nakasuhan or bakit wala rin sa rekomendasyon nyo na may dapat kasuhan na opisyal? Parati na lang kasing inmate, I think the officials are equally liable, and it was confirmed by General Magalong. Now, my question to you is, may kinasuhan na ba or meron ba kayong rekomendasyon na kasuhan itong tao na to na opisyal ng Bucor?
Mr. Chair, with the indulgence of my esteemed colleague, let me put it this way. Ang pwede lang mag-file ng kaso ay yung nag-imbestiga. So, it's the PNP. Okay? If in their findings, wala po silang nahukay o nakalap na ebidensya na liable yung gwardiya, ay wala po tayong magagawa. Maybe they were not able to find pieces of evidence to warrant the filing of the cases, both criminal and administrative. Kasi yung pagpa-file ng kaso, depende po dun sa mga ebidensya na nakuha eh. Kasi kung wala kang ebidensya, kung i-file mo yung kaso, pagtatawanan ka nung judge at saka nung abogado ng pinailan mo ng kaso, dahil nag-file ka, wala kang ebidensya. So, maybe based on the findings of the Philippine National Police, wala po silang nakitang ebidensya na magkaroon ng administrative and criminal liabilities yung mga gwardya. ang result ng kanilang fact-finding is that ang merong ebidensya na nakalap ay yung mga nanaksak. Ganun po yun. Any case that should be filed should be backed up by the pieces of evidence to warrant the filing of the case in court.
Mr.
Doon, wala silang nakuha ebidensya laban sa mga kwan. Sinabi nga nila na there's no evidence.
Yeah, if I may continue, Mr. Chairman.
Okay.
One more.
Go ahead, Honorable Tivis.
Yeah. Before you arrive, kasi, sir, tinanong ko kay General Magalong kung dapat ba liable yung tagabantay ng kontrolado na institusyon. Kaya nagulat nga ako na bakit wala sa rekomendasyon nila. Though sa fact-finding nila, wala silang nakalap na ebidensya, but ang sa akin lang, sir, is dahil controlled environment nga yun, equally liable daw yung tagabantay, which I also believe so. Ang sa akin, dahil may nangyari sa loob ng equal ng controlled environment, hindi ko maintindihan bakit hindi sinama sa kaso o sa investigasyon yung tagabantay ng isang kontroladong institusyon.
Mr. Chair, if I may note, Mr. Chair, there was a recommendation from the fact-finding that sana magkaroon ng operational guideline kung anong responsibilities ng PNP staff, which is also in NBP, at saka ng NBP. So it seems that based on their findings, baka may nagtuturoan, no, kung sino yung liable, no? So from among the sino nagbabantay. So maybe based on that recommendation, baka ganon yung circumstances that they found out na yung mga nagbabantay nagtuturoan, no, kung sino liable. At dahil kung wala namang guidelines, no, between PNP staff and NBP, no, ano bang area of jurisdiction, ano ba yung, di ba, anong oras siguro na magbantay. So in the absence of that, baka isa yan sa mga kailangan tingnan, no? If sa ngayon ba ay meron na bang guidelines?
Before probably General Magalong could make a final enlightenment on the issue, I would like first to recognize the presence of some members of the House who have arrived and attend this hearing. The Honorable Mercedes Cagas of the 1st District of Davao del Sur, the Honorable Edward Masida of the 4th District of Manila, and the Honorable Ron Salo, who is a member of this committee from the party list Akabayan. I'm sorry. Magkapinsan kayo, Akbayan and Kabayan. Yeah. The General Magalong, could you please make an enlightenment on the issue raised by the Honorable Tivis?
Thank you, Mr. Chair, Your Honor. One of the questions that was also raised during our informal meeting when we were reviewing the case is, are we not going to pursue administrative cases against the special shop personnel, special action force personnel who are actually guarding the facility? Ganito po kasi yung sitwasyon po dun sa Building 14. Ang Building 14, during the past administration, was under the exclusive control of Bucor personnel. Then, in August, or I think that was sometime in late July, the PNP Special Action Force were deployed and Building 14 was exclusively being guarded by PNP staff. Ngayon, ang tanong naman po ngayon is, kailan ho ba nakapasok yung ice pick? Was it during the time of the Special Action Force or was it during the time of the Bucor personnel? So, pinag-aralan po ng ating investigador, paano ba ang procedure during the time of the Special Action Force? Because it was determined that during the time of when Bucor was still guarding the facility, talaga pong uncontrolled yung pagpasok po ng contraband. That is well established po, considering the fact na halos lahat po ng sulok ng Building 14 may mga armas, may mga drugs, may mga bladed weapons, may mga martilyo, may ragare. But during the time of the Special Action Force, pinag-aralan po yung procedure. Paano ba ang procedure na pag-inspect? And if you, I haven't been to the NBP since SAF took over. But the way it was explained to me, yung procedure po nila, very impossible po, extremely impossible for any contraband to enter Building 14. And that's the reason po na nasabi ho nila sa akin, Sir, imposible po na yung ginamit na weapons o instrument nangyari po during the time of the Special Action Force. And that's the reason why we are not pursuing any administrative case against those guards, but mainly members of the Special Action Force who were on duty during that time, Your Honor.
Yes, Honorable Tibis, are you satisfied with the
Yeah,
explanation?
I get it. I understand it very well. Oh, wala ang sinasabi ko kanina, I was not concentrating really on kung sino yung nakabantay lang doon ang dapat kasuhan. Ibig ko sabihin, may hierarchy naman yun, di ba? Kaya tinanong ko kanina kung sino talaga yung, halimbawa, sa isang opisina, may kasalanan yung isang tao, papalo pa din yun sa manager. So, ang sa akin, kung kasuhan yung manager for remiss of duty, siya na bahala maghalungkat sa tao niya kung sino talaga ang may kasalanan. Ibig ko sabihin, kung may opisyal ng Bucor, dahil kahit may staff doon, Bucor pa rin yun, di ba? Oh, nasa umbrella pa rin. Kung kinasuhan yung Bucor, at sabihin niya walang kasalanan yung staff, di kasalanan ng una niyang tao na nakabantay. At least, merong mananagot na. That's what I was trying to drive at. Clear accountability kung sino talaga. Nakita ko kasi sa report, parang walang accountability kahit sinong opisyal na nakabantay sa NBP. When I said nakabantay, I didn't mean the staff or the guards only. When I say nakabantay sa isang institusyon, kasama na yung kung sino man ang may hawak talaga ng institusyon. So, yun lang hiningi ko, sir, na isama natin sa accountability kung sino yung dapat accountable. Hindi lang yung tama na yung may naturo tayong tao, sila na lang yung accountable. So I hope we are clear. Anyway, in line of that, as you said earlier, Mr. Chairman, in line with number 2.
Yeah, you can proceed.
Oh, ito kasi lahat, kanina nag-usap kami ni General Magalong on the sidelines because I also raised a privilege speech on this matter tungkol sa proper protocol ng pagre-raid ng kulungan. In our earlier hearings, nagtanong ako, di ba, kung tungkol sa warrant. So, may mga schools of thought na hindi na kailangan ng warrant dahil kontrolado naman yung environment. Ang isa kong tanong dun sa privilege speech ko, paano kung yung nagkocontrol ng environment ang kasama sa krimen? So yun, baka yun kailangan may warrant. Biglang nangyari yung sa Leyte, warrant naman yung ginamit. That's why I made that privilege speech so that we make an investigation again in aid of legislation. Ang gusto ko lang mangyari, lagyan natin ng proper protocol para hindi naman kawawa kasi yung police, di ba? Wala silang sinusunod. Kung wala kang sinusunod, it becomes discretionary. When it becomes discretionary, pwedeng maabuso. Lagay na natin walang abuso. Pwede pa rin silang magkamali dahil wala silang sinusunod na numbered protocol. So now, lumabas na to ngayon. Ano ba talaga ang dapat gawin? Kanina, sabi ni General Magalong sa akin, bago itong mga pangyayari, parang wala pang guidelines or wala pa to sa batas. So, tamang-tama, nandito tayo ngayon. After hearing all this, I would like to encourage my colleagues, pagtulungan natin to, gawa natin ang batas para matulungan naman natin yung mga opisyal, lalo na yung PNP, na meron silang masusunod sa kahit anong pangyayari na mangyayari in the future. And maybe I think General Magalong could also shed light on this matter, Mr. Chairman.
Yes, General Magalong.
Thank you, Mr. Chair, Your Honor. Malaking bagay po sa amin kung matutulungan niyo po kaming makagawa po ng certain provisions to help us really more come up with a more defined provision of law, especially when it comes to applying for search warrant in a government facility. Ano po? Maganda po yun sa amin. Yung nangyari po sa Leyte, there is no prohibition for any law enforcement agency or to the Philippine National Police not to apply for a search warrant on a government facility. No? I did it. Nagawa ko po yan. I was able to do it on my own office in Pampanga in 2014. I applied for a search warrant on a particular CIDG office sa Pampanga because during that time, my personnel, some of my personnel there, led by an officer, is already engaged in drug trafficking. You know? But this is another different type of government facility. This is a detention center. It is a correctional facility. This is a detention center na controlled na po yung environment. You know? Incarcerated na po, nakakulong na po yung mga tao. While we can apply for a search warrant, it is not a standard practice. It's not a standard practice po sa Philippine National Police. Kaya nga po, malaking bagay po sa amin kung talaga po ang ating mga legislators will be able to come up with a law guiding us on how to, properly serve search warrants, Your Honor.
Yes, Honorable Pibes.
Yan. Kanina, sabi ni General Magalong, walang prohibition na kumuha ng warrant, pero wala ding provision na kailangan kumuha ng warrant, lalo na sa controlled environment. Then again, we are here in aid of legislation. Kailangan natin to pagtulungan para magawan talaga kung ano ba talaga dapat. Because in a controlled environment daw, hindi mo na kailangan na warrant dahil kontrolado na nga yung environment. Pero ang isa din question doon, paano kung yung nagko-control ng environment, yun naman ang nagtatago ng mga kasalanan. So those are questions that need to be answered, and if also we also need to put make legislation pertaining to that, I think.
Mr. Chair.
Thank you.
Yes, the Honorable Akop.
Let's go to search warrants. This is within the purview of the jurisdiction of the Supreme Court. Wag na po natin pakialaman unless we want to tangle with the Supreme Court. Sila po nag-i-issue ng guidelines nito eh. That is why the Supreme Court has ordered an investigation insofar as the judges who issued the search warrants. So wag na po natin kuwan. Otherwise, we would violate certain constitutional provisions of the Constitution. So, now, insofar as the conduct of raid on controlled environments is concerned, the normal course of things is that you have to coordinate with the one who has control and supervision over the facility. For example, if we are talking about provincial jails, we know for a fact that it is under the control and supervision of the provincial governor. Kasi yung provincial warden ng provincial jail nagre-report sa governor under the administrative law. Doon. So, ang normal na gagawin ng mga law enforcement agencies to coordinate with the person who has control and supervision over the area. Parehas naman ng gobyerno yan Parehas na gobyerno. But, if you have concrete information that the provincial jail warden or the governor is in cahoots with what is happening inside the provincial jail, that is the only time na doon ka mag-apply for a search warrant. Dahil kung makipag-coordinate ka dun sa governor o dun sa provincial jail warden, mabubulilyaso yung i-conduct mo na raid. So, these things are supposed to be the exception rather than the rule. Ang rule kasi dyan is for us to observe yung protocol na may kipag-coordinate muna tayo dun sa tao na mayroong administrative and operational control over the establishment. Yun po ang kuha natin. Sinusunod natin na protocol.
Yes, one more, no? And then you...
Yeah. General Akop, Congressman Akop, I would like to ask, kung yung PNP sa amin kasi nangyari yun nag-report ako sa committee natin, di ba? Committee mo na mag-raid sila dahil may reklamo ako sa provincial jail namin na may tinatagong droga yung governor namin doon. Pero ang ginawa pa rin ng PNP, nag-coordinate pa rin siya sa governor kahit nabalitaan na nila na ang reklamo ko na in cahoots yung governor at yung jail warden sa mga nagpapalaro ng droga. Liable ba yung PNP na head nun? Dahil alam niya na gano'n, nag-coordinate pa siya, hindi na siya kadiretsong kumuha ng search warrant. Yeah, just a question.
That is if the Honorable Akop would wish to share again his expertise on the matter. Although for the information of the Honorable TVs, in our next hearing, the head of the Bureau of Jail Management and Penology, the Secretary of the DILG, and the representative of the local government units will be invited in the matter on how we will improve all correctional facilities, including jails, which are controlled by BGMP and controlled by the local government. Anyway, if the Honorable Akop may wish to respond, he may, and if otherwise, then we can proceed to the next item.
Mr. Chair, I'll just state that if any agency of government, law enforcement agent would receive an information, the first thing that he does is to validate that information. He will not immediately or readily act on the information given him. A veteran investigator or intelligence agent would validate first the information. And if he has proof that the person has control and supervision over the area to be raided, is in cahoots with those people inside, then the first thing that he does is to apply for a search warrant. Why? Because he has proven to himself that there's a need for a search warrant so that the person has operational and administrative control over the facility will not, shall we say, foil the operations to be conducted in that area. I think General Magalong was also occupied the office which I have occupied before, the chief of the CIDJ, can explain that matter more completely. Benji, trabaho mo ito eh. Hindi ako ang resource person dito eh.
Anyway, as I said, the Honorable Akop, it was optional on your part. And considering that we are now a little bit deviating on the items of the agenda, with the kind indulgence of the Honorable TVs, can we just reserve more detailed explanation on that matter once the ILG, the head of the BGMP, will be present in our next hearing. Now, let me proceed. No, I would like to ask our Sergeant at Arms, retired Lieutenant General Rolando Ditabale, and then to the PNP and to the NBI. What is now the status of the warrant of arrest issued by this committee against Ronnie Dayan? To our Sergeant at Arms, is he around?
Good morning, Mr. Chair. The Sergeant at Arms was here a while ago, but he left for a brief meeting with the Speaker.
Okay, you are his...
I am the Executive Director of the Legislative Security Bureau, Your Honor.
Okay, so you are competent to answer the question. Are you the one? You are part of the office that implements the order of the any committee.
Yes, Your Honor.
Okay, go ahead. What is now the status of the warrant of arrest?
Your Honor, the Office of the Sergeant at Arms sent a copy of its report this morning to the committee secretary, Your Honor. It was
We have not
received
yet
at
received.
9:15. Anyway, Your Honor, if I may
Yeah,
read the
go ahead.
report.
Make it brief.
Yes, Your Honor.
Ano yung status? Mahuhuli ba o hindi? O anong kailangan gagawin?
Your Honor, upon receipt of the warrant of arrest from the Committee on Justice, Your Honor, we immediately sent letters to the Chief PNP, the NBI, requesting assistance in effecting the service of the order, Your Honor. We also sent a letter requesting for escort and support team if Mr. Dayan's arrest will be effected, Your Honor. And the Sergeant at Arms also sent a memorandum to the chairman of the Committee on Accounts requesting for a budget, Your Honor, for the arresting team.
And then what happened? May budget ba binigay? O wala?
Yes, Your Honor. The request has been duly approved. The fund is readily available whenever the whereabouts of Mr. Dayan is positively identified, Your Honor.
We would like to know what is now the update. Can he be arrested in the next few weeks, days, or months, or years?
So far, Your Honor, we are still awaiting for the reports from the different intelligence agencies, Your Honor. We have tasked the AFP, the PNP, and the different, the ISAP and the Intelligence Security Group of the AFP, Your Honor, of the Army. Likewise, Your Honor, we have verbally coordinated with the Acting Provincial Police Director of Pangasinan, Police Senior Superintendent Oliver Lee. He has been providing updates, Your Honor. As soon as we receive the written report from the Provincial Director, Your Honor, we will submit this to the committee, Your Honor.
Okay. We all know of the recent development with the admission of former Secretary De Lima of her relationship with Ronnie Dayan. Then the testimony of Ronnie Dayan is really very material for the resolution of this illegal drug trade at the Bilibid. So we would like to hear from the Philippine National Police, the high-ranking official who is here, Director Magalong. There was that request from the Sergeant at Arms of the House of Representatives requesting your office to assist in the implementation of that warrant of arrest. May we know the steps taken by the PNP and an update on the possibility of an immediate arrest to the concerned person?
Mr. Chair, we've received the October 11 letter of the Office of General Tetabali 1 week after, sometime in the third week of October, Your Honor. And immediately, we sent out a flash alarm not only to Region 1, not only to our regional office in Region 1, but in all other regional offices of the police, of the Philippine National Police. We have also directed Police Regional Office 1 to create tracker teams, Your Honor. And in 2 occasions, raids were conducted in Orbistondo and vicinity, Your Honor. But unfortunately, the result was negative. The latest update is that our tracker teams continue to scour Pangasinan area and other provinces, Your Honor. We haven't received any significant information as of this date.
Okay. From the National Bureau of Investigation, may we hear from Deputy Director Ferdinand Lavin? You have received request for assistance from the House Sergeant at Arms relative to the implementation of the warrant of arrest issued by the committee. May we know what action or steps taken by your office?
Yes, Mr. Chair. Your Honors, since the day we received, since the time we received the order of Congress to conduct operations to locate and arrest Mr. Ronnie Dayan, we coordinated with General Ditabali. We have very good coordinations with him. We are pursuing very good leads, Your Honor. However, much as we would like to discuss in detail the operational procedures we are applying in the matter of trying to locate and arrest Ronnie Dayan, we do not want to jeopardize the ongoing operations of the NBI. We have created teams, Your Honor. We have tapped our regional offices, not only in the northern Luzon, not only in central Luzon, but in nationwide, Your Honor. We do not want also to compromise the safety of our cooperating informants who are providing us good leads. And as we discuss this in Congress, Your Honor, I believe Ronnie Dayan is watching us.
Okay. The Honorable Gary Alejano, you were asking for recognition earlier.
Thank you, Mr. Chair. And magandang tanghali po sa lahat. I just would like to clarify with this committee if this is the only hearing scheduled for the purpose of investigating the riot inside the NBP on September 28, 2016.
Inasmuch that the Bucor officials and NBP officials are absent today, so we intend to include this in the agenda when we will have our committee hearing at the National Bilibid Prison. Sometimes on March, because by December the committee will hold hearing in Davao, and then Cebu on January, and Palawan on February, and then the schedule for the Quezon City and Manila City jails will be scheduled also on March, together with that of the NBP.
Thank you, Mr. Chair. Stated here that such agenda is under the paragraph motu proprio investigation. And I just would like to inform the committee that this representative and along with 5 other members of this House filed resolution number 421 2 days after the incident happened on 28 September. We filed this 30 September 2016, and the resolution is about directing the appropriate committee to conduct an inquiry in aid of legislation on the alleged riot at the New Bilibid prison that claimed the life of a high-profile inmate and injuring 4 others with the end in view of proposing remedial legislations to address the security and safety in our prison facilities. Was this ever considered in coming up with the agenda of the committee? Because we would like to know, because I was not informed by this committee.
As of today, we haven't received yet a copy of your resolution. Probably under our existing procedure, it is still with the Committee on Rules, or probably the Committee on Rules had referred it to the mother committee. But for purposes of today's hearing, this is in connection with the approved resolution of the mother committee of the Committee on Justice when we adjourned last October 17, where the subcommittee on correctional reforms is directed to conduct further hearings in relation to the 4 issues that are enumerated in item 3 of today's agenda.
Thank you, Mr. Chair. That's unfortunate, considering that it was more than a month ago that we filed this resolution, because I think it's very important to go through the details of such incident, because it has to do, something to do with our investigation on the alleged drug trade inside the NBP, and plus the fact it was stated in the news and even by the CIDG that Tomas Duninia was requested or ordered by a friend from the Navy in order to stop J.B. Sebastian from testifying before this honorable committee. So we have to know that because if we will not go through the details of it, we might find ourselves someday seeing things like Mayor Espinosa dead inside detention center. And yun nga yung tanong ko rin, what is the assurance now that these considered drug lords are safe inside detention? No? Although we don't, first, we don't condone illegal drugs in the country, but the point is, if these things are happening inside controlled facilities such like NBP, then there must be a clear problem when it comes to our justice system in the country. So, with that, Mr. Chair, I would like to request if I can propound some questions to the CIDG.
Go ahead, Honorable Alejandro, and after you, we will now proceed to the next item in the agenda, which is the lowering of the minimum age of the criminal responsibility. You have the floor.
Thank you, Mr. Chair. Tanong ko lang po sa CIDG, meron po kayong possession ng CCTV sa loob ng Building 14. Because I was informed in the last hearings of this committee na meron pong maraming CCTV inside NBP. So meron po bang sinabmit na CCTV recordings doon sa Building 14?
The CIDG may answer.
Thank you, Your Honor, sir. The NBP OIC caused the submission of CCTV recording to our officer.
So wala pa po?
Meron na po. They have caused the submission of the CCTV recordings.
So meron ho kayong nakita doon? Maliwanag ba yung incident ng stabbing incident?
Yung mismong incident po ng stabbing ay hindi po covered ng CCTV kasi yung pong loob ng mess hall saka yung pong side ng area ng kubol ni Tonico ay wala pong CCTV sa lugar na yun.
Sa loob ng mess hall, that is a common place?
Yes,
Walang
sir.
CCTV doon?
Wala po, sir. Kaya isa po yun sa naging recommendation namin na lahat ng common areas and yung sa mga individual cells magkaroon din po ng CCTV.
Thank you. Are you aware of the reason why JB Sebastian was transferred to Building 14? Kasi alam mo natin na yung Building 14 kasi tama yun, halo-halo yan. No? Diyan nilagay yung NBI 19. When they were transferred from NBI back to NBP, doon sila nilagay. At the time, wala pa naman si JB Sebastian doon. Si JB Sebastian was in maximum security. Would you know the reason why, in spite of the threat to his life, he was transferred to Building 14?
The CIDG may answer if ever you are competent to answer. If ever. Go ahead, General Larsco.
Mr. Chair, Your Honor, wala ho kaming, hindi namin alam yung reason kung bakit na-transfer doon si JB Sebastian.
Thank you po. Natanong ko lang ho yun dahil itong NBI 19, before the investigation at yung nagkaroon ng investigation, sinasabi nila na si JB Sebastian ang dahilan kung bakit sila nalipat, na-raid at saka nalipat sa NBI. Kaya galit na galit itong mga NBI 19 na ito kay JB Sebastian. And in spite of that fact, he was still transferred inside Building 14. Kumbaga, pinain mo sila doon sa loob na alam mong galit na galit itong NBI 19 sa kanya. So, dapat lumabas sa investigation nyo yan. Ano bang motibo ng mga nagsasaksak sa kanila? Inutusan ba siya? Patahimikin siya? O talagang galit na galit itong mga nakulong sa NBI? And since you don't have the answer, I will go to my next question. Are you aware of the information also in your investigation na may na-receive ba kayong information na talagang itong mga inmates na ito considered as drug lords ay talagang ililiquidate inside detention center? Are you aware of this information?
Your Honor, wala ho kaming nare-receive na ganyang information, Your Honor.
Thank you, sir. I stated this information because nabanggit ko na rin po dati ito na meron po ako na-receive na information na itong mga inmates, high-profile inmates involved in drugs ay talagang ililiquidate inside detention center. No, hahanapan lang ng paraan. And the information that I received, magkakaroon lamang ng isang event like surprise drug testing, and then magkakaroon ng riot doon, and they will be stabbed to death. No? So, kaya nga nag-file kami ng resolution because we want to know further. Hindi po malayo na after this, magkakaroon po ng scenario inside detention center at ito ay mangyayari. Ngayon po, si Clarence Donggail, member po ito ng PNP dati. Tama po ba?
Yes, Your Honor.
Are you aware if he has a continued coordination with PNP or some members of the PNP?
Sir, wala ho kaming information tungkol dyan.
Thank you for that information, but I guess we have to really investigate kung sino bang nakakausap ni Clarence Donggail. Dahil sa information ho natin, si Clarence Donggail ang kinakausap in order to organize the hit squad inside NBP. So dapat alamin po natin ho yun. Dahil siya nga nag-initiate at itong kasama nila si Tomas Duninia, magkakasama ho sila. No? Even if they are not in the same gangs, magkakasama ho sila nung hatian ng presidio at saka karsel. No? And would you know kung meron pang continuing threats sa itong mga high-profile inmates? Sir?
Your Honor, actually, yan yung isang nabanggit ko nga kanina kay Superintendent Ebreo na to continue with his investigation. Kasi it seems na nag-zero lang siya doon sa liability ng mga persons involved in the actual stabbing or in the incidents. So siguro medyo na-overlook niya or at this point in time of his investigation, medyo wala pa siyang pieces of evidence or witnesses na magsasabi na mayroon ng involvement ng iba pang tao tungkol ho dun sa binabanggit nyo. So, as of this time, sir, hindi naman namin isinasara yung investigation tungkol dito, sir. At I already instructed Superintendent Ebreo to continue with the investigation.
Thank you, sir. Tanong ko lang po, General Magalong, sir. Dahil po yung Building 14 ay kontrolado po ng SAF sa ngayon. Totoo po ba yan, sir?
Yes, Your Honor.
And yun nga po, nung sila ay nag-take over, sila po yung nag-assure o kung binigyan sila ng order na walang mangyayari doon dahil sila ang responsible noon. At nabanggit yung nga kanina, hindi natin alam kung kailan pumasok yung ice pick na yan o droga na yan, before ba or after. Ngayon po na alam na ho natin at palagi po yung inspection doon, ma-assure po pa ng PNP or through SAF na wala pong mangyayari na katulad sa nangyari noon ng stabbing incident at hindi po malagay sa langanin ang kanilang buhay dahil I continue to receive information coming from the families of those inside the detention na meron pa rin threat sa buhay nila. No? So, can you give us the assurance na wala pong mangyari na ganun?
Your Honor, immediately after that incident, nag-usap po kami ni General Benji Lusad, who is the head of the Special Action Force. At binigyan niya po ako ng assurance na hindi na po mangyayari yung ganun.
Thank you, sir. Mr. Chair, next time around, I hope to ask questions from officers of the Bucor and NBP. Dahil marami pa po akong pwedeng tanungin. But for the meantime, ang gusto ko lang pong i-mention na itong mga nasa loob ng kulungan kasi hindi na ito pwedeng manlaban, kaya hindi po pwedeng patayin. No? And considering the fact na may nakikita ho tayo ngayon on the streets, isa, dalawang sachet ay pinapatay na ho, no? Either by vigilantes or by the PNP in their official or formal operations. And much more, ito yung mga drug lords na sinasabi na nanggaling dito sa loob ng NBP, talagang hindi malayo pong mangyari sa kanila yung nangyari kay Mayor Espinosa. Kaya nga, in the spirit of our justice, Mr. Chair, dapat matingnan ho natin ito. Hindi po tayo, kumbaga, namamanhid lang o nasasanay na talagang pinapatay ang lahat na related sa drugs. Although we don't agree, we don't support yung drug lords and we should stop illegal drug trades in the country. Ang hindi lang ho natin napapayagan yung pagsira ng ating justice system dahil dito po nakukuha ng taong bayan ang kanilang security and trust sa gobyerno. So with that, Mr. Chair, maraming salamat po.
Okay, thank you very much, Honorable Alejano. And in relation to your query as to the status of your resolution, I had requested the COMSEC to verify with the records and with the Committee on Roles. And on October 19, the Committee on Roles referred your House Resolution number 421 to the Mother Committee. And with this development, we would like to confer with our committee chairman, the Honorable Omale, so that if this will now be referred to our subcommittee on correctional reforms, we will include this in the agenda in our December committee hearing. And with the kind indulgence with the other members, our resource speakers in the item number 3, we have only up to 1:30 and to use this hall for another committee hearing. So we have to proceed now to the next item of the agenda, which is the House Bill numbers 2, 505, 935, 1609, 2009, and 3973, the Minimum Age of Criminal Responsibility Act. So in this connection, I would like to ask the sponsors, as I call your name, to deliver your sponsorship speech in brief, as much as possible, probably to adapt your explanatory note and to just highlight in brief the important or salient points of your bill. And for the resource persons, some of you, we had already received your position paper, and then we will give you 5 minutes each, no, to highlight the salient points of your position on the proposed bill. So to start with, may I recognize the Honorable Deputy Speaker Representative Castro for the sponsorship speech of his proposed bill. You have the floor, sir.
Mr. Chairman, to abbreviate proceeding, being the principal author of House Bill number 2, I am adopting the explanatory note of House Bill number 2 to be my sponsorship speech. In compliance with the suggestion of the distinguished chairman of the committee, the salient points of the proposed legislation is already incorporated in the explanatory notes. And again, to maintain abbreviate proceeding, I would like to adopt that as my manifestation on the salient points of House Bill number 2, Mr. Chairman. Thank you.
Thank you very much, the Honorable Castro. This time, may I call on the Honorable Cagas for her sponsorship speech of her proposed bill.
Thank you, Mr. Chairman. May I request that the explanatory note of my bill be adopted as my sponsorship speech. Thank you.
Okay, thank you very much, Honorable Cagas. May I call on now the Honorable Swansing for her sponsorship speech.
Thank you, Mr. Chair. I would like that my explanatory note will serve as my sponsorship speech. I just would like to emphasize that my bill, now this is lowering into 9 years old. Thank you, Mr. Chair.
Okay, your bill lowers the minimum age of criminal responsibility to 9. Honorable Cagas is also 9.
Yes.
The Honorable Castro is also 9. Are there, of course, the last to deliver his sponsorship speech is my idol, the Honorable Romeo Acop.
Thank you, Mr. Chair. In order to save time and in order to have more time to discuss these amendments to Republic Act number 9344, otherwise known as the Juvenile Justice and Welfare Act, I would also manifest that the explanatory note of my proposed bill would be taken also as my sponsorship speech. Thank you, Mr. Speaker.
Okay, thank you very much, the Honorable Acop. This time we will call on our resource speakers. First, the representative of the Honorable Aguirre, the Secretary of the Department of Justice, Attorney Mangoba.
Yes, good afternoon, Mr. Chair, again. Insofar as the department is concerned, considering the number of bills submitted for consideration, we are still, the said bills are still under study, and we request more time to finalize our position on the proposed measures, and we hope by the end of this week to submit the copy of the position paper to the Secretariat, sir.
Okay, noted.
Thank you, sir.
The representative of the Honorable Judy Tagiwalo of the Department of Social Welfare and Development, is she around? Yeah, Attorney Oko. Okay.
Good afternoon, Mr. Chair. I'm from the Juvenile Justice and Welfare Council. This is an attached agency of the TSWT. And one of our mandates in the JJWC is to provide advisory function and recommend policies and strategies to the government in order to ensure that the administration of juvenile justice is effectively administered. And as a result, although we do not have an official position paper with regard to the lowering of the age, we submitted comments on the possible effects of lowering the age of criminal responsibility to 9 years old. And as a result, I will just discuss, Your Honor, some of the main concerns that we have if the age is lowered. And this is because also, based on our experience, because we do monitoring on the implementation of the present law, RA 9344. And if we've studied the bills, and most, if not all of them, are really towards institutionalization of children, not only those 9 years or over, but it will also allow the institutionalization of children who are 9 years and below if we follow the proceedings based on a lowered age. And our main concern would be it will prove difficult for the government to comply with the lowered age, especially when it comes to institutionalization. Particularly, it will be costly to the government because it will require a lot of construction of institution. We have made an estimation of how much it would cost the government for next year if we lower the age, and we've submitted it to the Committee on Justice. And for next year, it will entail an estimate of 10 billion for the government to just construct the institutions. Right now, our law provided us an allocation of 400 million for the construction of institutions for children. We were given for this year 40 million for that. One Bahay Pag-asa would cost 20 million, and it does not include operational costs. And we will support in the national government, we will support the LGU that will construct that with a 10 million, and the other counterpart will be, the 10 million counterpart will be given by the LGU for a total of 20 million. Right now, a lot of them are interested to construct, but when we provide them the requirements for the construction, there are no takers. So doon lang po sa 40 million namin, nahihirapan na po silang mag-construct. So ang nangyayari po, even if we all don't want them to go to jail because of lack of facilities, doon lang po tayo concentrate sa 15, over 15, marami na po sa kanila ang napupunta pa rin sa institutions at saka sa jails. So if we go back to lowering the age, we will go back to the situation before RA 9344, which is more children will really go to jail. And this will not just be detrimental to the children, it might also be detrimental to us as a society, because we will not be secured of good rehabilitation programs if they are mixed with adults and other children who commit graver crimes. Likewise, we have a discussion before with other countries. For instance, meron po tayong mga countries na lowered na yung age nila, like Singapore, but actually yung 7 ng Singapore, it's not 7 talaga, kung hindi 12. 7 lang, but if the child proves not to be matured enough, 12 po yung kanilang minimum age. And their institution is really way, way far from what we have in the Philippines. Yung sa kanila, maganda po yung institution nila. In fact, mukha siyang mga parks and hotels. But for us, yung mga institution natin existing for children, and we've done some monitoring last January, para pa po silang prison condition, and they do not comply with the standards required by our law and as well as international law. And at the international community, our attention has been called for the degrading and ill treatment that we have been given we are providing these children in our institution. Our present law, with regard to the issue of syndicates, yung ginagamit yung mga bata sa syndicates, as well as children below the minimum age of criminal responsibility, our present law, when it was amended in 2013, already addressed those issues, because children who are below the minimum age from 12 to 15 can already be institutionalized in youth detention centers for intensive rehabilitation for a minimum of 1 year if they commit serious crimes or they keep on repeating their offenses, or if their best interests require them to be placed in an institution. So even with that, na binabaan natin yung age of institutionalizing children, hindi pa rin natin masyadong nagagawa because we lack the facilities. Ang pinaka-problema po natin ngayon, hindi po yung lowered age, kung hindi yung implementation ng batas natin, and the fact na maraming mali yung pag-implement ng batas. So, like for instance ngayon, we are partnering with the PNP and provide to help them implement the law properly. Kasi marami pa rin sa duty bearers natin as a whole, they think na pagbata, papakawalan. But it's not the case. The law just requires a different procedures depending on the age of the child. But even if they are below the minimum age of responsibility, they should be held accountable for the offenses they commit. So yun po yung summary ng comments namin.
Mr. Chairman, may I know from the lady whether the position that she has discoursed is also the official position of the DSWD?
Director Oko, will you please answer?
Okay. Ma'am Sally from DSW. May I give the
No.
floor?
You first, no, Director.
Yes po, sir.
You are the one asked
Okay, sir.
whether your position is the position of the DSWD. You answer it yes or no.
Yes, sir.
Okay.
Therefore, because when DSWD was called, you were the one who signified and asked yourself to be recognized. But is there any other representative of the DSWD here? Could you please identify yourself?
The lady would please identify yourself and your position.
Good afternoon po, Your Honor. I am Rosalie Dagulo, OIC Assistant Bureau Director of the Protective Services Bureau of the TSWD. And if I may be allowed, I would like to read the official position of the department on this subject matter.
Before you will read your position, earlier when I called the DSWD, Director Oko presented herself being the Executive Director of the GWC, the Juvenile Welfare Council, no, which is an attached agency to your office. So, meaning your position will be different with that of the GWC, because if it will be different, then I will give you another 3 minutes to highlight that position. But if it is the same, then the presentation of Director Oko would already suffice.
Your Honor, it is the same in terms of not agreeing to lowering the minimum age of criminal responsibility.
Mr. Chairman, I'm sorry to interrupt the chair.
Can we have the questioning later on? We will allow first.
No, I will not really ask question. But you know, in consideration of these bills, lowering the minimum age of criminal responsibility to 9, the prime department of the government that is very much concerned about this is the DSWD. Therefore, the representation of the department should not be left to lower officials of the agency. It should be the department secretary herself who should be around. If she really cares for the welfare of the children or the youth of this country, she should personally involve herself here. Could you please convey that message to your secretary?
Before the good lady will answer, I'd like to ask the committee secretary whether an official notice was sent and duly received by the secretary of the DSWD regarding today's hearing.
Yes, Your Honor. We sent the letter invitation to the secretary herself, and I believe that she was the one who designated our present guest to represent her.
Okay. The OIC Director, you are officially mandated by the Secretary to represent here in today's hearing.
Yes, Your Honor, because we have our presentation of budget hearing at the Senate at the same time. So I was designated by the Secretary to represent the department in this hearing. Thanks,
Okay.
Chair.
Can you please convey to here the manifestation of the Honorable Deputy Speaker? At least if she is not available, one of her undersecretaries or assistant secretary should have accompanied you. Okay. The Honorable Swansing, is that an interjection? Go ahead.
Just a follow through to Deputy Speaker Castro. Next time, can we ask them to give us an official letter of authority that they are the authorized person to appear in the hearing, Mr. Chair? Thank you.
Okay, duly noted. The committee secretary is directed to observe that procedure. To the Department of Justice, I understand earlier that you had the official designation from your secretary to appear on today's hearing.
Mr. Chair, my instructions came from Undersecretary responsible for legislative affairs.
Is it a written authority? Do you have your written authority?
None, sir, but I only have here a referral slip from his office.
Okay. What about the DSWD, ma'am?
I was designated actually by our Undersecretary Vilma B. Cabrera to represent the department. And the protocol of designating officers really come from the Secretary, and that is being instructed to our Undersecretaries.
And your designation is a written designation?
Yes,
you
I
have
am
your-
designated as
Okay. Please furnish copy of that designation to the committee secretary.
You have a written designation with you?
written designation to represent in this hearing, sir.
Yes, you have a written?
No, it's
Oh.
just a handwritten instruction from my director.
You
to
have a
represent-
handwritten instruction
Yes,
from your director?
from my director, yes.
Not from the secretary herself? Because it was the
Not
secretary.
from Secretary Judy
It was the
Taguiolo
secretary
directly.
who was invited, was not the director.
Okay, please convey
Mr. Chairman.
the same manifestation of the Honorable Crisologo.
Mr.
to your
Chairman,
secretary.
can I interject?
Yes, the Honorable Masida, please.
Yes, so para malinaw kasi nung tinanong ni Deputy Speaker Castro si Attorney Oco if she represents the department, sabi niya yes, but it seems that since there's another one here, so maybe Attorney Oco's statement is represents the stand of the attached agency, not the entire DSWD department. And when what's the name of the other representative?
I am Rosalie Dagulo.
Yes, Assistant Director Dagulo, when she was asked if she shares the same view. Actually, hindi tapos yung sagot niya. Sabi niya, she shares the same view that it should not be lowered, but she was, parang may sasabihin siya na yung reasons nila are different. Magkaiba yung rason ni Attorney Oco nung attached agency at magkaiba yung rason niya. So kung siya talaga yung officially designated ng DSWD, it's up to the chairman. We would like to know the official stand of the department on such an important measure.
Along this line, I ask the designated director to please convey to Secretary Taguiolo to furnish this committee the official stand of the department. Only one official stand to be signed by her. And we'll appreciate it very much if that will be forwarded to this committee not later than 10 days from today.
Mr. Chairman,
Yes, the Honorable Crisologo.
in follow-up with the Honorable Maceda from Manila, perhaps you would like to listen to the designated representative of the SWD that she stated a while ago that you have the same stand with regards to the law and order, but I think for a different reasons. May we ask for what are the different reasons, Mr. Chairman?
Okay.
Ask her to continue.
Yes, upon the manifestation of the Honorable Crisologo, the good director is allowed to make a 3 minutes presentation on your position, the salient points on your position.
Mr. Chairman, before the good director proceeds with her discourse, may she be able to advise the committee on whether what she is going to state is approved by the Secretary of DSWD?
Your Honor, we actually submitted our official position to the chairperson of the Committee on Justice, to Representative Reynaldo Umali, dated October 21, 1916. And this is signed by the Honorable Secretary Judy Taguiolo.
If that's the case, the issue is clear. Then you may continue.
2016, Mr. Chairman, hindi 1916. Para lang malinaw.
Just for the record, our COMSEC had just handed to me the position paper of the DSWD, although dated October 21, 2016, but it was received by the committee on just the other day, November 14, 2016. Now, but anyway, go ahead, go there. Make it brief. Yeah, any interjection from the Honorable Cagas?
Yeah, thank you, Mr. Chair. Before the representative of the Department of Justice,
The representative
I'm sorry,
of the DSWD.
will make some comments on that. I would just like to move that the committee subpoena the secretary in order to enlighten this committee on the official stand of the DSWD. Thank you.
There is a motion. Is it Jolie seconded? No. To subpoena the Secretary of the Department of Social Welfare and Development to shed light on the position that he had submitted. Is there any... there's a motion, Jolie seconded. Any remarks?
Mr. Chairman,
go ahead.
You know, we have to give respect also to the Secretary. Perhaps we could invite her for a second time instead of issuing a subpoena to her with respect to a different branch of government. So perhaps, we could send personally one of the members or to call her up. We know her anyway, just to ask her to come so that, because it's a very important matter. And because, you know, if we subpoena, we will be creating a rift between the DSW Secretary and the Congress. So I would suggest, I'm not objective, of course, but I would suggest that we just invite her again formally.
Okay, what is the pleasure of the movement? Instead of subpoena, it should be letter of invitation. The Honorable Cagas, please.
Well, I accede to the motion of Congressman Crisologo, but in the next time that they will not be here, so we will take necessary action on that.
I agree, Mr. Chairman.
Okay, the motion instead of subpoena would be another invitation to the Secretary of the Department of Social Welfare and Development to appear personally before this subcommittee. Are there any further remarks, comments, objections?
Mr. Chairman, perhaps we could ask the representative now of the TSW to convey to the Secretary that we are, aside from the written letter that we will send, we will invite her with the condition that the next time that she invited and she does not appear, as requested by the Honorable Cagas, we will issue a subpoena.
Yeah, after the chair would bang the gavel for the approval of such motion. So any other further remarks or comments to the motion? The chair hears none. The motion is approved. The good director, before you will make your 3 minutes brief presentation, is also requested to convey to your good secretary on the duly approved resolution of this subcommittee. Go ahead now. You have.
Thank you, Your Honor. Let me read this position paper of the DSWD. The DSWD strongly objects to the intention of House Bill number 935, an act amending certain provisions of Republic Act 9344, otherwise known as the Juvenile Justice and Welfare Act of 2006, and for other purposes, in House Bill number 3973, an act lowering the minimum age of criminal responsibility, amending for the purposes RA 9344, otherwise known as the Juvenile Justice and Welfare Act of 2006, introduced by Representatives Tobias Tiangco and Estrelita Biswan Singh, respectively, to lower the minimum age of criminal responsibility from 15 years old to 9 years old. We believe that the proposed measures should be reconsidered due to the following reasons. Lowering the minimum age of criminal responsibility has never resulted in lower crime rates. The Philippine experience and the experience of other countries attest to this fact. 2, there is a need to distinguish between making children responsible for their actions and criminalizing them. RA 9344 makes children responsible without making them criminal and holds children accountable in entirely non-punitive, welfare-based, and education-oriented measures. 3, lowering the minimum age of criminal responsibility runs counter to available scientific knowledge about the cognitive, psychosocial, and neurological development of children. 4, a lower age of criminal responsibility results in more children being detained, substantially higher cost of public expenditure,
and an even higher social cost of reoffending and graver offending, which simply demonstrates that such measure is not cost-effective. 5, lowering the minimum age of criminal responsibility is anti-poor, as the available data shows that the greater majority of CICL come from lower income families where parents are either unemployed and or where a greater number of siblings result in even lesser per capita resources. And 6, lowering the minimum age of criminal responsibility violates the fundamental principles of social protection of children as provided for by law and by international treaties and internationally accepted standards and principles. The concerned legislators and concerned agencies should invoke continuous support for training and monitoring of prosecutors handling cases of children in conflict with the law to promote more child-sensitive and gender-sensitive standards and processes in the conduct of inquest, preliminary investigation, and prosecution of all CICL cases for the consideration of the committee. Thank you. Very truly yours, Judy Tagiwalo, our secretary. Thank you.
Okay. This time we hear from the representative of the chairperson of the Commission on Human Rights, Attorney Manahan.
Good morning, Mr. Chair, and to the members of the Honorable Committee. I'll be reading the official position of the Commission on Human Rights on the proposal to lower the minimum age of criminal responsibility. The Commission on Human Rights...
Panyera, with kind indulgence, how many pages are your position?
I will just be reading the key points here on.
Yeah, please, no, because we are only until 1:30.
I understand. Thank you, sir. The Commission on Human Rights reiterates its strong opposition to any amendments which will lower the minimum age of criminal responsibility. We affirm our previous stance that lowering the minimum age of criminal responsibility oversimplifies the nature of juvenile offending and violates the fundamental principles of child protection and welfare as provided for by laws, international treaties, and internationally accepted standards and principles. Juvenile offending will not be resolved by simply lowering the minimum age of criminal responsibility. This will only subject more children into the adult justice system instead of addressing the underlying causes of both juvenile offending and victimization. The lowering of the minimum age of criminal responsibility also violates the fundamental principles of child protection and welfare. The principle of protecting a child's well-being and development is entwined with that of their best interests. It encompasses the need for additional measures and protections due to a child's vulnerability and the duty of the state to provide this protection as enshrined under our Constitution, domestic laws, and in various international human rights instruments, specifically the UN Convention on the Rights of the Child. The CRC, or the Convention on the Rights of the Child, which the Philippines has ratified on August 21, 1990, recognizes the right of every child, alleged as, accused of, adjudged, or recognized as having infringed the penal law to be treated in a manner consistent with the promotion of the child's sense of dignity and worth, taking into account the child's age and desirability of promoting his or her reintegration and assuming a constructive role in society. And yet to this issue, the CRC provides that state parties shall seek to promote the establishment of laws, procedures, and authorities and institutions specifically applicable to children in conflict with the law, and in particular to establish a minimum age below which children shall be presumed not to have the capacity to infringe the criminal law. Article 40 of the said convention is complemented by Rule 4 of the UN Standard Minimum Rules for the Administration of Juvenile Justice, or the Beijing Rules, which states that the minimum age of criminal responsibility for juveniles should not be fixed too low, bearing in mind the emotional, mental, and physical maturity of the children. While the instruments of international law do not set a minimum age of criminal responsibility, the Committee on the Rights of the Child provided guidelines for the establishment by stating in a general comment that minimum age of criminal responsibility below that of the age of 12 is considered unacceptable by international standards. It further urges state parties to raise their minimum age to a higher age level, taking into account the developmental differences and decision-making capabilities of children and young people. I would like to state our recommendation. So in lieu of the proposed legislation lowering the minimum age of criminal responsibility, the Commission on Human Rights therefore recommends that the government fully implement Republic Act 9344 as amended by Republic Act 10630 by allocating funds for building or restoring the Bahay Pag-asa facilities in every province and highly urbanized cities. Number 2, by employing multidisciplinary personnel that will provide individualized and efficient community-based and or center-based intervention for children in conflict with the law, the victims and their families. Number 3, by continuously capacitating all professionals working with the juvenile justice system on relevant international standards and the JJW. Number 4, to regularly visit the Bahay Pag-asa facilities and other youth homes to assess the operations and physical conditions of these facilities and to monitor the human rights situation of the children detained therein, and popularizing through information dissemination the basic provisions of the JJWA and restorative justice for better appreciation of the public. The Commission further recommends that the law enforcers step up their campaign against syndicates who are using minors to commit crimes, while keeping in mind that in these cases, children should not be treated as criminals but victims who need to be rescued and protected. That's all, Your Honor.
Okay. Representative from the NBI, the Honorable Deputy Director, what's your position on the matter?
Your Honor, on the matter of lowering the criminal, the age of criminal responsibility, we have submitted our position paper signed by Director Dante Giran. In essence, Your Honor, we believe and maintain that the criminal age should be 12 years or older, because as this is reflective of the true emotional, intellectual, and mental maturity of the child.
Okay, so your position is you are agreeable to lower it from 15 to 12? No.
That's correct,
because
Your
the
Honor.
bills, the bills filed are for lowering it to 9. Okay. This time from Director Magalong, representing the Philippine National Police. What's your position on the matter?
Your Honor, we're favorably endorsing the proposal of the National Bureau of Investigation.
Okay. Thank you very much. Do we have a representative from the Integrated Bar of the Philippines? And then Council for the Welfare of Children, no representative. Children's Legal Rights and Development Center. Yes, Ms. Legaspi, you are recognized.
Good afternoon, Your Honor. We'd like to highlight some of our concern in the position paper that we have submitted to the committee. First, the current bills that seek to lower the minimum age of criminal responsibility claim that the numbers of youth offenders increased dramatically in the past years, and they are growing in numbers. It is our position that the focus should be on questioning why there are more crimes committed and how they could be prevented. Lowering the minimum age is not the solution. In most cases, children in conflict with the law come from economically deprived areas and they often experience violence in their immediate social environment. And taking this as the basis of improvement could not just minimize criminality, but even more, they can strengthen the administration of juvenile justice. And two, the children in conflict with the law need to be protected, not detained. The violations of the law are mainly connected to the laxity in the social system. If the syndicates, parents, or other adults abuse minors to perpetuate their criminal actions, this can be prevented through improvement in the social welfare system. Then syndicates would not exploit children. The lowering of the MACR only lowers the age of the abused children in reality, and this would be completely contradictory to the main purpose of the child's best interest. If our goal is to protect our children, our call is to punish severely those who use and take advantage of them and break their innocence. The failure of the system to go after the syndicates that use minors reflects weakness of law enforcement in implementing the law. And we also it is also our position that a full implementation of the law deter children to commit crimes. Children who came in contact with the law, even if they are exempt from criminal liability, they cannot just go scot-free because they have civil liability. And according to the law, the children has to undergo an intervention program, which is until this date is the defective part of the implementation, the intervention program. It is sad to say that children in detention or the children in conflict with the law are seen as criminals. For the information of this honorable committee, all children in detention centers are victims. For the past 15 years, we are conducting monitoring visits to all detention centers. We call it detention centers because they are not in compliance with the Bahay Pag-asa requirement or the standard. No? So we witness how the situation or the situation of the children there. And we see that some children we have met some of them were trafficked, some were from Mindanao. When we interviewed them, they ended up in detention center for just stealing chocolates or candies. We have met CICL girls and boys who were victims of exploitation, pimped and prostituted, but they ended up at the detention centers for just loitering around the streets and were charged with vagrancy. We have met CICL who were neglected by parents, abused, raped by a family member, abandoned, and adopted by relatives who forced them into hazardous labor. And then why they are at the holding centers? They are seen by the public as criminals, not as victims. CICL were more than thrice victims of different circumstances. And it is our position that these children should be taken care of. Their main issue at the center are the absence of their access to education, access to justice, and access to health. Health and human rights are the major rights deprived of a CICL. And if we put the 9-year-old above into detention center, then it is like we perpetuate the sufferings that they have already endured. And with due respect to the bill that compares our minimum age, that other countries have lower minimum age, it is our position that making international comparisons means trying to compete at an international level without considering different social and economic conditions. We cannot just pick out just one law of a whole system and try to impose it on the Philippines, who have a complete different political and social background. If we take, for example, Western Europe as an example, for criminal liability at the age of 13, we have to bear in mind that their judicial treatment is completely different, and their standard of accommodating youth offenders are higher, and they don't detain children. So it is our recommendation that a full implementation of the law must be taken for consideration by the Honorable Committee, and also that the establishment of Bahay Pag-asa must be mandatorily pursued or applied. And lastly, since the Philippines has ratified the UN Convention of the Rights of the Child, it says that in all actions concerning children, whether undertaken by public or private social welfare institution, the courts of law, the administrative authorities, or legislative bodies, the best interest of the child shall be the primary consideration. Thank you.
Okay. From the Public Attorney's Office, Attorney Dimitri Huert.
Good afternoon, Your Honor. We have already submitted to the committee secretary our comments slash recommendation to the proposed House bills proposing for the lowering of the age of criminal liability. And we are amenable to the lowering of the age of criminal liability to 12 pursuant to General Comments number 10, which was issued by the Committee on the Rights of the Child, which committee was created pursuant to the UN Convention on the Rights of the Child. Thank you, Your Honor.
Okay, thank you. From the Ateneo Human Rights Center. Okay, from the Psychological Association of the Philippines. Wala. Philippine Action for Youth Offenders.
Thank you, Your Honor.
Well, please identify yourself.
I am Melanie Liana from the Philippine Action for Youth Offenders.
Okay, go ahead, ma'am.
Yes, the PAYO, the Philippine Action for Youth Offenders, is a coalition of 16 civil society organizations and individuals. We strongly oppose the proposal to lower the minimum age of criminal responsibility from 15 to 9. We believe that this move undermines the best interest of the child and will not solve the problem of children committing crimes. It distracts us from pursuing the real reasons why children offend or reoffend, such as poor parenting and supervision, peer pressure, social isolation, family conflict, poverty, use of children by criminal syndicates, and lack of prevention, intervention, and diversion programs at various levels. Scientific research in the fields of neuroscience and psychology, particularly in child and adolescent development, provide convincing evidence that young people should not be held to the same standards of criminal responsibility as adults. A 9-year-old child's decision-making capacity is certainly not the same as an adult's. The immaturity of young people due to their brain underdevelopment, as neuroscience evidence shows, impairs their decision-making capacities and increases their susceptibility to perform risky behaviors or antisocial behaviors. Although young people may be able to discern right from wrong, because actually even a 3-year-old knows that it's bad to hit, bad to lie, it is their capacity actually to act on this discernment, to be able to use the knowledge that they have to make informed decisions and to understand the long-term ramifications of their actions that are undermined. We stress that this is not to condone or tolerate the wrongdoings of children. We as adults must be able to help children understand that what they do have consequences and that they should make things right if they have harmed anyone. This is the premise of the RJ Restorative Justice Paradigm under the Juvenile Justice and Welfare Act. The question is, how do we hold children accountable for their wrongdoings, especially young children, those below the age of 15 who are the subject of our discussion today? Do children cease to be children because they have offended? Perhaps the tragedy lies in our perspective about children when we see them as small adults rather than children. Do we treat them like how we treat adult criminals, sending them to jail when they offend, expecting that they will become good people after languishing for long periods of time in dismal prison conditions with no rehabilitation programs for them? There are some legitimate concerns that must be dealt with in terms of implementing the JJWA, and we recognize that. But we believe that these must be addressed by means of thorough study of processes to assist children at risk and children in conflict with the law. We fully support the full implementation of the Juvenile Justice and Welfare Act, and our other arguments on this matter have already been presented by the other resource speakers today. Thank you, Mr. Chair.
Thank you very much, Panira. Before we will proceed, I would like to recognize the Honorable Congressman Gonzaga. From the UNICEF, Attorney Annie Sagisag.
Good afternoon, Your Honor. I'm Marie Michelle Munoz of UNICEF.
and UNICEF stands with the multi-sectoral group on fully implementing the current version of the law and not to lower the minimum age of criminal responsibility. UNICEF expresses concern over these legislative proposals. First, the adolescent brain, one of the most remarkable findings in neurobiology in the last decade, is the extent of change that can occur in the adolescent brain. Basic intellectual abilities reach adult levels before the process of psychosocial maturation is complete. This is because the neocortex, the portion of the brain responsible for reasoning and impulse control, is the last part of the brain to develop. On the other hand, several studies have shown that toxic stress, such as dysfunctional families, could damage brain architecture. Recent systematic reviews of evidence across a range of international contexts consistently reveal high levels of neurodevelopmental disorders among incarcerated young people, with rates that are grossly disproportionate to the equivalent levels among the general youth population. Number two, the best interest of the child. In all decisions taken within the context of the administration of juvenile justice, the best interest of the child should be a primary consideration. Thus, it is incumbent upon the government to recognize that children differ from adults in their physical and psychological development, including emotional and educational needs. Such difference constitute the basis for the lesser culpability of children in conflict with the law. Number three, a child has the right to life, survival, and development. Cognizant of this right, the legal framework on juvenile justice should support the child's development. Number four, jail is no place for a child. It is alarming for children to be institutionalized. Depriving children of their liberty would have long-lasting effect on a child's physical, mental, and emotional health, harming the overall development of the children. It stigmatizes children as criminals and creates an environment to ensure reoffending, often extending to adulthood. To keep them in jail while they are so young will also contribute to an already overcrowded prison system. Fifth, there are no evidence that putting children in jail decreases criminality. However, evidence from a range of project reviews, evaluations, and meta-analysis shows that such diversion programs and other alternatives to detention can reduce offending by up to 70%. Six, government has had many gains in juvenile justice administration. In fact, in 2015, JJWA was nominated in the world's best laws and policies to secure children's rights. It was organized by the World Future Council in partnership with the Inter-Parliamentary Union and the UNICEF. Seven, the international obligation. The Philippine government, as a state party to the UN Convention on the Rights of the Child, committed to develop and implement a comprehensive juvenile justice policy. Thus, UNICEF is in favor of maintaining the current law, and it is of its view that the full implementation is what is really needed, and not lowering the age of criminal responsibility.
Okay, thank you very much, ma'am. From our PCLPD, Mr. Dongito.
Magandang tanghali po, Mr. Chair. Maraming po salamat sa pagkakataon. This position paper was, I think, submitted to the committee, and I would like to read, if you will allow, Mr. Chair, just a portion of our position paper. As an organization of legislators committed to strengthen legislation on population and human development, the Philippine Legislators Committee on Population Development Foundation gives primary importance in promoting the rights of vulnerable and marginalized sectors, most especially children. We would like to express our opposition to any move that will threaten or reverse our gains in the protection and promotion of children's rights and welfare. The Juvenile Justice and Welfare Act is a landmark piece of legislation which PLCPD supported and it established a comprehensive and child-sensitive justice system where children can be held accountable for their actions but will prohibit incarceration. It focuses on the prevention and rehabilitative aspects and the notion of restorative justice. The amendatory law RA 10630 emphasized the responsibility of the duty bearers and society to establish a protective and enabling environment for children to veer them away from a life of criminality. At this point, we want to push forward, Mr. Chair. When looking at juvenile justice, we respect our position is that we should consider the environment which affects the growth and development of children and predisposes them to certain behaviors or makes them more vulnerable to coercion from adults. The situation of many Filipino children is very stark. 1 out of 3 Filipino children lives in poverty. 1 out of 10 Filipino children experiences involuntary hunger. Every day, 2.8 million children in youth are out of school. So this, in a way, affects the conditions and the mindset of our children. We should adhere to our international obligations. The Philippines adopted several international agreements, such as the United Nations Convention on the Rights of the Child, but particularly for the UN Committee on the Rights of the Child, in General Comment Number 10, it states that the minimum age of criminal responsibility below the age of 12 years is internationally unacceptable, and further recommends the age of 16 years old. We believe that the weak prosecution of adults enables the criminal exploitation of children, and lowering the age of criminal liability runs counter to the intention of juvenile justice, which presumes that children should be considered as victims. Finally, Mr. Chair, and to the honorable members of the committee, we push for the full implementation of JJWA, and we strongly support House Resolution 241, which calls for a review of the effectiveness and value of the JJY in light of the current deliberations, and examine any evidence supporting the proposal to lower the minimum age of criminal responsibility and substantiate the claims of effective implementation of JJWA. Finally, we recommend stronger oversight of Congress to ensure the full implementation of the law. There are gaps. It includes poor enforcement of the allocation of internal revenue allotment to strengthen the local council for the protection of children, and inability of local implementers to efficiently conduct the intervention and diversion programs in light of gaps in their capacity, resources, and manpower. We thank the committee for welcoming our recommendation, and we look forward to more opportunities for collaboration in the future. Thank you very much.
Thank you very much, Director. From the Humanitarian Legal Assistance Foundation, Attorney Arbitria.
Magandang hapon po, Mr. Chair. Magandang hapon po, members of the committee. Maraming salamat po sa pagkakataon. Ang Humanitarian Legal Assistance Foundation po ay isang NGO na tumutulong na maipatupad ng maayos ang Juvenile Justice and Welfare Act sa mga local government units. Napakahirap po ng kailangang pagdesisyonan ngayon kung ano ang magiging minimum age of criminal responsibility. Pero ang aming NGO po ay tumututol sa pag-criminalize ng mga mas batang tao or criminalizing younger people, katulad na halimbawa ng mga 9 years old. Bakit po? Unang-una, academically speaking, concern po namin, ano po ba ang criminal justice theory na pinanggagalingan o nagiging batayan ng pagbababa ng age of criminal responsibility sa Siam. Kung maalala po natin sa Pilipinas, tayo po ay nasa classical theory. Ang ating revised penal code, ang ating criminal justice system ay classical theory and positivist theory. Ano po bang ibig sabihin nun? Ang classical theory ay nagmumula din or nag-emanate sa social contract theory. Anong ibig sabihin? Na ang bawat tao, katulad natin, ay nakakaunawa kung anong ibig sabihin o anong responsibilidad natin sa pamayanan. Alam natin kung ano ang duty natin, ano ang responsibilidad natin. To the extent that kapag hindi natin ginawa yung responsibilidad natin sa pamayanan, tayo ay pinaparusahan. May penalty po yun. Now, ang tanong po doon ay, sino po ba ang may kapasidad na pumasok sa social contract? Sino po ba ang may kapasidad na makaunawa ng kanyang role, ng kanyang responsibilidad sa pamayanan? Yan po ay yung napakahirap na trabaho natin ngayon. Buti na lang po, noong 2006, ito po ay nilagay sa 15 years old. Base sa research ng PAYO at research ng PLM, kung saan nakita natin na sa Pilipinas, ang discernment ay nasa 15 years old. Sa ngayon po, wala pa po akong nakikitang panibagong pag-aaral na ito ay pinapalitan yung mga scientific study na yon. So ngayon po, kaya po kami ay tumututol doon kasi para bagang sinasabi natin na ang 9 na taong gulang na bata ay nauunawaan na niya kung ano ang kanyang role sa pamayanan. Now, napakadali pong sabihin na ang bata ay alam na ang tama o mali. Pero may konteksto po kasi yan. Halimbawa, ang bata siguro na 4 years old, 5 years old, alam niya ang pula ay hindi blue. Ang blue ay hindi yellow. So alam niya po kung ano ang tamang kulay, alam niya kung ano ang maling kulay. Pero po kapag pinag-usapan natin kung ano ang tama sa batas, ano ang consequences ng kanyang ginagawa sa batas, baka mag-iba po ang konteksto, baka mag-iba po ang ating mga sagot. So yun po yung aming pinaninindigan na baka ang 9 years old ay masyadong bata para maunawaan niya ano po ba talaga ang role niya sa pamayanan natin. And ito din po, kung tatandaan natin ang ating revised penal code 1930s po, 9 years old po yung age of criminal responsibility. Pero ito din po yung mga taon kung saan pinapakasal na rin po natin ang mga 14 years old at 16 years old. So marami na po ang nagbago simula nun. And of course, meron na po tayong mga neuroscience research na sinasabi nga, underdeveloped pa ang prefrontal cortex ng ating mga adolescents, ng ating mga kabataan, kung saan ito yung nagkocontrol ng kanyang decision making. Kung baka sinasabi natin, masyado pang mapusok ang mga bata. Dahil nga po doon sa underdeveloped na prefrontal cortex. Pinag-uusapan din po natin, noong 1930s, wala pa pong human rights. Wala pa rin pong children's rights. Kasi 1989 lang po pumasok yung United Nations Convention on the Rights of the Child. Kung saan nagbago ang pananaw ng mundo sa ating mga bata. Kung saan tinitingnan natin ang ating mga kabataan na hindi yan isang bagay na pag-aari ng mga adults, kundi isang tao na kailangan nating tulungan upang maging kapakipakinabang na mamamayan eventually pag sila ay naging adults na. Which is why, kami sa Humanitarian Legal Assistance Foundation ay naniniwala na napakalaking bagay ng Juvenile Justice and Welfare Act of 2006. Dahil hindi lang po yung mga bata na mabubuti or yung mga babata na hindi pasaway ang binibigyan natin ng karapatan na maging kapakipakinabang, kundi ibinigay din ito kahit doon sa mga bata na at risk of being in conflict with the law, and even to those who are in conflict with the law. Kasi nga po ang tingin natin sa mga bata ay still under the formative years. Kaya napakahalaga po ng isang juvenile justice and welfare system na hindi ginagawang kriminal ang isang bata, bagkus tinuturuan sila na maging responsable para sa kanilang ginagawang mga kasalanan sa pamamaraan na naaangkop sa kanilang edad. Ngayon po, marami ang nagtatanong, hindi naman po nadideter o hindi naman natatanggal yung juvenile delinquency ng Juvenile Justice and Welfare Act. Unang-una po siguro hindi po talaga mawawala ang juvenile delinquency. Palagi pong merong ganon. Ang basis din po niyan, yung science din nga, medyo mapusok ang mga bata. Pero ang napakahalaga po ay meron po tayong sistema na sasaluhin ang mga batang ito in case na sila ay magkasala. At ngayon, yung Juvenile Justice and Welfare Act po natin, substantially, pwede na po siya na sumalo dito sa ating mga CICL at Children at Risk. Yun nga lang po, ang isang challenge po sa Juvenile Justice and Welfare Act natin, yung mandato ay ibinigay sa local government units para yung LGU yung mag-handle ng children at risk at children in conflict with the law. Yun po yung nakita namin na pagkukulang. Dahil po pagdating sa baba, sa LGUs, hindi po naunawaan ng LGUs kung ano ang gagawin nila. So ang recommendation po namin, una po, hopefully, mas palakasin natin yung LGU, capacity building po, para maibigay nila yung tamang pagtugon doon sa problema ng mga CICL para ma-prevent po nila yung juvenile delinquency.
Okay. Thank you very much, Paniro. Now, we will call on Ms. Rosemary Trajano, from the Philippine Alliance of Human Rights Advocates. Wala. Okay. So,
Mr. Chair, may I make a manifestation? Or do we have another round of
we still have. Yes, we have only one. Okay. We call on Carlo Manano, Salinlahi Alliance of Children.
Yes, thank you very much, Your Honor. Carlo Manano from Salinlahi Alliance for Children's Concerns. And kami po isang National Alliance of 24 Child Rights and Welfare Institutions, organizations, and programs. And we are strongly opposing the proposal to lower the minimum age of criminal responsibility of children with the law from 15 to 9 years old. I will be reading from our position paper, which we will be gladly submitting after this committee hearing.
You just summarize.
Yes po, I will just read some points.
Okay.
Right. We firmly stand at the premise that current societal realities are a major contributing factor to children's involvement in criminal and antisocial acts. Proxy indicators of poverty, which include unemployment and landlessness among peasant families, malnutrition, and poor health conditions, disenfranchisement in education, and inaccessibility to other basic social services create a complexity that jeopardizes the rights and welfare of children, placing them in conditions of extreme desperation and hopelessness. As a civilized society, we should place great value to our children. Thus, we should exhaust all means to ensure that their basic needs and rights are protected and their welfare upheld. As the primary duty bearer, state authorities have a greater responsibility to fulfill this role and create an enabling environment for children to become responsible members of society. We should therefore regard children in conflict with the law as victims of state neglect and abandonment. Their right to survival, to develop, and be protected has been denied from them at one point of their lives. They have been failed miserably by the society that now wants to brand them as criminals. The current proposal to lower down the MACR creates an even stronger statement that the state is willing to completely abandon its responsibility to these children, making them outcasts, left to tend for themselves and with no chance of redemption. So I will not be reading, I will go straight to our recommendations. With this in mind, we are reiterating our call to stop any proposals to lower the age of criminal responsibility. Instead, efforts should be poured towards ensuring adequate and proper implementation of the law, establish more Bahay Pag-asa, and support initiatives that provide for the rehabilitation and reintegration of children in conflict with the law. Conduct widespread dissemination of the provisions of the JJY and its implementing rules and regulations, coupled with educational campaigns on children's rights and child development, targeting all stakeholders, especially law enforcers and service providers, so as to enhance general understanding, awareness, and knowledge of the JJY. Undertake a regular comprehensive study of children under intervention programs to assess their condition, as well as the rehabilitation programs designed for them. This will stand as basis for reforms and innovations to improve the whole juvenile justice system. A nationwide survey of BCPCs, or Barangay Council for Protection of Children, should also be conducted in order to assess the needs for their creation and or functionalization. Aside from developing the capacities of BCPCs in terms of implementing diversion programs for CICL, there's also a need to strengthen their function as a primary line of defense in preventing children to get involved in destructive activities. BCPCs should design programs that will promote the holistic development of children and youth and encourage their meaningful participation in social affairs. Such programs may include the formation of children and youth organizations, leadership trainings, and educational sessions that would foster in them a sense of responsibility to their communities. But after all things are said and done, the government should go beyond strengthening the implementation of the JJWA if it is serious in its campaign against criminality. Responsive programs and policies to address poverty, which includes job generation, genuine land reform, and access to free basic social services such as health and education should be top priority. For as long as children and their families are stuck in the quagmire of poverty, criminal acts, whether by adult or children, will continue to proliferate. Thank you very much, Your Honor.
Okay. With the kind indulgence of our resource speakers and the members present, there is another schedule here at this hall, another committee. So for lack of material time, we are duty bound to resist and hold another hearing for this particular bill. And the chair is proposing to the members if we could meet next week on Monday at 1:30 because 22 and 23 there are another committee hearings of the Committee on Justice for another subcommittee. So may I hear from the members what as to your pleasure with regards to the rescheduling next week. Of course, we have other committee hearings scheduled on December and January for the other subject matters, and that is in relation to the correctional facilities and security management of the different jails and the national believe it. But for this bill, so is it all right for you if we will meet on Monday, 1:30 in the afternoon? Any pleasure, any motion?
Mr. Chair,
Yes,
before we are going to ask the members for another meeting on Monday, I would just like to ask the chairman that I'm going to manifest my stand because by Monday I will be in Davao. It's because I have the reason because that is the birthday of my husband.
Okay. So there is no problem. You have already delivered your sponsorship speech insofar as your bill is concerned, and it is duly noted. If you want to make additional manifestation, you can do so now. I'll give you 1 minute more before the other committee will complain.
Thank you, Mr. Chairman. You are really a friend of mine. Mr. Chair, the opposition of the different concerned national government agencies as well as the non-government organization is well taken and noted by this representation. I may just explain why I was able to come out with this bill. It's because I want to protect the interests of the children. This is based on my personal experience in my own province. They are using children at the age of 9 because they can squeeze just a small hole in the house, and even for an electrical wire, they are being used and exploited by the criminals because they can sail the tanso which is under the plastic. And then secondly, how many times that I personally bring all those children to the DSWD in Davao in order to make a strong recommendation for education. And then thirdly, I am also a witness of how they kill person because they are also hired by these syndicates. That is why I am here, because I am also a nanay, and I know the sentiments. If you said poverty and all what you have explained, I sympathize with your your son, but for me, this is really personal experience on my part. That is why being a congresswoman representing my constituents and my genuine and honest conviction in order to help protect the interests of these children. That is why I was able to come out with this bill. And may I go further, Mr. Chairman, that after hearing the explanation from the different organizations, it is the belief of this representation that the measures at hand would deter the prevalence of crime to be committed by minors under the proposed measures. Furthermore, the proposed measure will protect our children for exploitation of syndicates, which is proliferating at the moment because of the exempting circumstance under the present law. It is therefore imperative to this representation herself, a mother, to humbly submit this bill for approval, and thank you.
Okay, manifestation duly noted. The Honorable Brosas would like to make another manifestation.
Yes, Mr. Chair. I just would like to add in the next subcommittee meeting some of the, I think, will help us also as resource speakers. Please ensure to invite Dr. Lian Alampay, the Psychological Association of the Philippines, for the explanation of the science-backed brain maturation of the child. So we will be guided as lawmakers, no, of her explanation. She has a very good explanation on this. And if she may be given a presentation, time for that. And next, I would like to add, if there is a representative of the DILG, because I will have questions on the implementation. No, DILG. From the, and also the League of, what's this? Local Council for the Protection of Children and the Barangay Council for the Protection of Children. Can you please add those as resource persons for the next, and please, may I also manifest my position. Well, accordingly, my position is this. Last August 2, I had a privileged speech with regards to the lowering of the age of criminal responsibility. I would like to reiterate our stand from Gabriela Women's Party that children are not are victims and not criminals because of the following reasons. Of course, they all told us that the poverty and the out-of-school children that we have, the forced labor, child labor, and also I would like to add that we should ensure children's access to basic social services and not to prosecute them, and prosecute the criminals that lure children to commit crimes, and also ensure full and proper implementation of the Juvenile Justice Welfare Act. That is our belief. Thank you very much.
Okay.
Just a short note, Mr. Chair.
Before that, the chair is directing the committee secretary to extend the invitations as manifested by the Honorable Brosas. And I'm sorry, my distinguished colleagues, the chairman of the next of the committee that will use the room is already here. So,
Mr. Chairman, before we adjourn, I would like also to, I hasten to add that I would also want to have a representative from the Department of Education and also a representative from the National League of Barangays of the Philippines.
okay.
Mr. Chairman,
The secretary is so directed. Go ahead, the Honorable Crisologo.
may I also request that the religious organizations be invited, like the Catholic Church and the different...
The president of the CBCP had already submitted their position. No, the Catholic Bishop.
How about the other religious organizations?
Okay, the secretary is again directed to extend invitation to other religious
The Iglesia ni
organizations.
Cristo,
Yeah.
and the big...
Okay, so for lack of material time, the chair declares a recess.
Okay na, sir?
Naiiyak ako kanina. Kasi naalala ko yung mga bata yung binilisip natin pag nagbabasa. For example,
Puro bakal yun pala.
So, anong ibig sabihin ng case example na ginawa natin?
Ha?